Welcome, everyone, to the Fourth Circuit this morning. It's good to have you here, and we look forward to hearing your cases. This is number 22, this first case, is number 22-1280, Coalition for TJ versus the Fairfax County School Board. Mr. Varelli, good to have you with us, sir.
Good morning, and may it please the court. I'm Don Verrilli for the Fairfax County School Board. The admissions policy that the board adopted for Thomas Jefferson High School is constitutional. It is 100% race neutral in design. There are no quotas, no targets, no racial preferences of any kind, no racial classifications of any kind. And it is 100% race blind in its administration. No application contains any racially identifying information, so all applicants are judged on a race-blind basis. The policy reflects no intent to discriminate against Asian Americans or anyone else. There is no such evidence, and the coalition does not contend otherwise. Even if one grants the coalition its characterizations of all the evidence on which it relies, and much of it is mischaracterized, but even granting those characterizations, and even attributing to the board as an official matter statements by the superintendent and statements by individual board members, all you have is an expression by the board that it had a purpose to increase opportunities for African American and Latino students to gain admission to TJ, groups who had been historically underrepresented. There is nothing unconstitutional about that purpose, so long as it is pursued through race-neutral, race-blind means, and that is exactly what the board did.
Well, even if this court is persuaded by the argument that, racial balancing to match the demographics of your area is for its own sake, is constitutional. Say the court's persuaded by that. But isn't there still evidence that that the coalition claims shows an intent to discriminate against Asian American students? Don't we still have to construe the facts in the light most favorable to the coalition and draw inferences in their favor on that sort of secondary purpose, even if the court agrees with you that, balancing for its own sake, fine, not unconstitutional. But there's the text messages, there's the pie charts, there's a lot of argument in your brief about how to construe those things. You disagree with the coalition about that, but don't we have to draw the inferences in their favor when we're considering summary judgment for you?
So I think it goes back to, I'll answer Your Honor's question directly, but I do think it needs to be framed. And I also want to circle back to the racial balancing issue too, if I could, but I'll go directly to Your Honor's precise question first. In terms of summary judgment for us, our cross motion, you're correct about the way to draw inferences, but all of that evidence establishes is an intent to increase the opportunities for African American and Latino students. There is no evidence of any animus against Asian American students. And if you look at page 56 of their brief, they concede that on page 56. They say, well, yes, it's true, there's no smoking gun, but you wouldn't expect a smoking gun. But the point here, there's a much broader context than that. But we didn't say just that there's no smoking gun evidence. We said there's no evidence, period. And they didn't point to any evidence about discrimination directed at Asian Americans. And so,
there's text messages about how this will affect Asian American students, and you tell me I should read them to mean the board members were concerned, they were solicitous, they didn't want to have that impact, but the coalition says, look, it shows they knew it was going to do that, and they, went ahead with it anyway. Is that a dispute of fact or law?
So I think whether it's a dispute of fact depends on the legal standard that one applies. And we think if you apply the correct legal standard here, you look at what the board did. And I will just draw the court to the board's resolution, which is at page JA 624, where the board's resolution says, we are not engaging in racial balancing, we are not engaging in racial targeting, we're not doing anything of the kind. And I think then if you look at the way the plan is implemented, and I will say I do think that if one actually looks at the statements, they really are serious mischaracterizations, and the court
But
can
that's
see
just,
that.
that's an example, right? There's also a dispute about what did the board mean by diversity? You would have us look at the pie charts that break students down by race and then have underneath it, little figures about other groups of students. You would have us look at that and say, it wasn't about race, it was about something else. And the coalition says, no, you need to say it's about race. So that's a dispute of fact that I think prevents us from granting summary judgment in your favor. That's a big ask.
No, I respectfully, Your Honor, I disagree with it. I think it's a perfectly reasonable ask on this record because getting back to what the legal standard is, under Feeney, they have to show that the board acted because it wanted to discriminate against Asian Americans. That's the test they have to meet under the Equal Protection Clause. Nothing to do with racial balancing or anything else. That's the test they have to meet.
Mr. Verrilli, I sort of feel like the discussion between the parties about the question of racial balancing is sort of like two ships passing in the night, because I think part of the problem is that you're both using that term to mean totally different things. Can you tell me what is the coalition's definition of, what is your client's definition of racial balancing that you think the court needs to apply here?
I think you're exactly right, Your Honor, in that we apply different definitions of that term, and I think it's critically important. I appreciate the focus on it. Our understanding of racial balance is the Supreme Court's understanding of racial balance as defined in Fisher and in other cases, which is setting specified percentages for each racial group and then trying to achieve those targeted specified percentages. And that is what the district court claimed we did. It said that we...
And the district court said there was racial balancing.
Right, and racial balancing defined in this way.
Was that an error of law or fact or both?
It's an error. It's both. It's an error of law because the ship's passing in the night. Their definition of racial balancing is any consideration, any purpose to increase opportunities for any particular underrepresented racial group in a zero-sum environment. That's their definition of racial balancing. That is not the Supreme Court's definition of racial balancing. There is no support in any case law for understanding that as racial balancing or as impermissible intent generally. There is none whatsoever. And if it were the case that it was considered racial balancing, then, for example, the University of Texas Top 10% plan would be unconstitutional racial balancing. And now I acknowledge that the Supreme Court did not hold that that plan was fine in Fisher, but it clearly endorsed that as an appropriate race-neutral alternative to providing racial preferences in admissions decisions. And even Justice Scalia and Justice Thomas in their dissents in Fisher pointed to that as a way to improve diversity, quote, without discrimination, unquote.
So when the board said in its resolution, the goal is to have TJ's demographics represent the NOVA region, and the demographics that the board had seen, there was a breakdown by percentage of race in the NOVA region. I guess I'm wondering, you're asking us to read that and say, well, that's not a reference to matching the demographics, doesn't mean achieving a certain percentage, it means something else. But if it meant achieving a certain percentage, would that be an impermissible purpose?
So I just want to focus on that document. The very next page of that document says that what the board is talking about is socioeconomic considerations.
It's one of many, yeah, but I guess even putting aside the document, we can read the document in context, and again, that's a factual dispute, but I just want to ask kind of the legal question that if the goal is to match demographics, which have been broken down by percentage, would that be, and if they came out and said that very clearly, putting aside what we actually have here, this is a hypothetical, would that be an impermissible purpose?
So I think looking at that document, of course, it was about a different proposal.
Yes, I'm asking you a hypothetical document. Imagine a document that says our goal is to match the demographics of the region, add in even racial demographics of the region. And there's a pie chart showing the racial demographics of the region with the percentages. Is that an impermissible purpose?
I think you can't do what Fisher says you can't do, which is to specify percentages and then adopt a proposal that gets you to those percentages.
Right, but here, again, I'm asking, is that an impermissible purpose, even if you then go on to adopt a neutral, facially neutral policy? Because we're here on an intent claim.
So, well, but you have to, respectfully, you have to look at what the board actually did. And what the board did, first of all, it had a resolution.
There were 4 resolutions altogether, weren't there?
That's right, Your Honor.
And only one was adopted.
That's correct.
That's the one.
So was that a yes or a no?
Only one.
So the answer is, and I apologize, I don't think you can answer cleanly yes or no, because it's always going to depend on surrounding context. And surrounding context here is critical. What they did was adopt a resolution saying they were not engaging in racial balancing, they were not targeting. If one looks at what they actually did, they adopted.
I'm just trying to find out, as a legal matter, take a hypothetical as a legal matter. Our stated purpose is to match the demographics of our area. Here are the demographics of our area. X percentage African American, X percentage white, X percentage Asian American. Is that an impermissible purpose?
If you disembody it and consider it all by itself, then I think it can be considered an impermissible purpose. But that isn't this case. One has to look at what the board actually did. The board took an official action and it repudiated racial balancing in the resolution. And it adopted an approach which no reasonable person can understand as racial balancing.
So, Mr. Varelli, you and Judge Rushing have had an extensive discussion about how to interpret various documents, but for purposes of reviewing the district court's actual holding, don't we have to construe all the inferences in your favor? The district court granted summary judgment in favor of the plaintiff.
Yes, certainly, certainly with respect to the coalition's motion, that's absolutely right.
Which is what the district court granted, right? That's the motion.
That's absolutely right. But I guess what I'm trying to suggest is that the idea that this was an effort to do what the district court described it as, which is to align admissions percentages with the demographics of the county, is not just wrong, it's completely unreasonable. Just look at the numbers. Asian Americans are 19% of the county population, 54% of the admissions.
You may have done it poorly. You know, in McCrory, African American voting increased after the legislature took the actions that our court said were intended to discriminate and prevent African Americans from voting. So, you know, it's absolutely relevant. You're right. We cannot look at this in a vacuum. But I don't know that the fact that it didn't match up exactly solves everything. It's one factor.
No, I think it goes way beyond that, Your Honor. I think this is an Occam's razor situation. The one possibility is that they were trying to accomplish that and they were completely incompetent and they missed it by a million miles. The other possibility is that they weren't trying to accomplish that. And that is by far the clearer explanation for what happened.
Is that a question for a fact finder?
No, it's clear on the face of it, Your Honor. There's an official board resolution saying we aren't doing it. The policy isn't designed to do it. The policy didn't accomplish it. And so if you look at all of those facts, those are the material facts. And if you put all those material facts together, there is no reasonable basis for concluding under any circumstances that this is racial balancing. It just isn't. And so, and I do think that that is the key problem with the case that my friends on the other side are advocating here. Their theory, it really comes down to this zero-sum idea. It's really not a racial balancing case because there is no record support for that. This is a case about where their argument comes down to the proposition that in any situation in which there are a limited number of opportunities, so government employment, government education, government contracting, et cetera, any effort on the part of the government to improve opportunities for historically underrepresented groups will necessarily violate the Equal Protection Clause because it's foreseeable in those circumstances that it could reduce opportunities for other groups. That is a radical, radical notion. There is no support in any case for it. They haven't identified any. It would be completely inconsistent with the endorsement of the top 10% plan in Fisher, with the endorsement of small and disadvantaged business set-asides in Croson, on and on and on.
Well, and foreseeability is obviously not enough, right? Feeney says it has to be because of, not in spite of.
Right, and and their whole case depends on that, and it's wrong as a matter of law. And that's why what they describe as racial balancing really is just another version of making their zero-sum argument. What they're saying is, it's racial balancing because you're moving some numbers one way and some numbers the other way. But racial balancing as a matter of law means something very, very different. And the board did not, and there is not a basis in the record for concluding that it did engage in that kind of conduct. And if I could just make one point about McCrory, Your Honor made a point about McCrory that I actually wanted to make, which was
You're welcome.
that on page 232 of the opinion, the court notes that actually African-American participation turnout went up under the new system. The district court, mimicking the argument that my friends on the other side made, was that McCrory endorses what the district court said and what they said is a simple year-over-year comparison, okay? That very point that Your Honor made demonstrates that they are completely wrong about that, because if it were a simple year-over-year comparison and turnout went up, they would have no disparate impact claim. And that's the argument.
Well,
that the
instead,
court
our
rejected.
court's response was, well, but there's other evidence of disparate impact
Well-
that came before. And then we said, and look at the rate of change year over year. We looked at year over year, but we looked at the rate of change rather than the turnout itself. So it's, in different cases, why can't you look at it different ways?
Well, so 2 points about that. I actually think the prior page, 231, which remarkably my friends on the other side cite, is the key page in McCrory. And what that page says is that within the confines of the newly adopted electoral system, African Americans are disproportionately disadvantaged as compared to other races. That's exactly the disparate impact test of Ward's Cove and Hazelwood that we're advocating for. And I think it's clear on page 231 of the opinion that that's the test that this court applied in McCrory.
We didn't adopt a Title VII test for the Equal Protection Clause.
No, but once again, just as with their zero-sum theory, there is no case law adopting their simple before-after comparison as a basis for disparate impact. And it really can't be, because if you think about disparate impact that way, then any governmental change is going to be liable to a disparate impact attack, because...
But you can't, this is not a disparate impact claim, right? This is a discriminatory intent claim. We're talking about equal protection. So it's not enough to have the statistics. You have to have evidence of intent, which is quite difficult.
Right, but their argument is, yes, I completely agree with Your Honor about that, but their argument is that that kind of discriminatory intent, a desire to discriminate against Asian Americans, can be inferred from the disparate impact, what they describe as a disparate impact. But there isn't any disparate impact in the way that the law understands disparate impact. Now, that's not to say they might, in a different case than this one, might be able, a party might be able to point to direct evidence of that kind of animus to prove a case like the one they want to prove, but you don't have anything like that here, nothing. And as I said, if you look at page 56, they concede that they don't have that evidence, and that their argument is the zero-sum argument, that the discriminatory intent is, in their words, necessarily implied by the fact that this is a zero-sum situation.
Mr. Borelli, what's the relief that you seek today?
Excuse me, Your Honor, I didn't hear.
The relief you're seeking today, what do you want us to do?
So we want you to reverse the district court's judgment of summary judgment for the coalition and direct the district court to enter summary judgment on our cross motion, because we believe there is no material dispute of fact under the correct understanding of the equal protection law. I know I've gone way over my time.
Very good,
here,
sir.
Your Honor.
That's
Thank
fine.
you.
As long as you get questions.
And I don't mean if there are any other questions. No. Okay.
Any other questions? Thank you very much, sir. Ms. Foster? You represent the United States of America?
That's right. Sydney Foster for the United States.
Good to have you with us.
Thank you very much. It's nice to be here. I wanted to start by thinking about the consequences of the theory that the coalition is advancing and that the district court adopted. It makes no sense to conclude that promoting equal opportunities is a suspect purpose, because it would inappropriately freeze in place the status quo. Imagine we had, for example, a school district that was operating an elite selective public school that happened to be nearly all white. And imagine that the school district came to realize that some of its policies were precluding many qualified students of color from gaining admission. Maybe it had like a steep admissions fee or something of that like. It can't be the case that the Equal Protection Clause forbids the school district from addressing that problem, thus freezing in place this situation in which individuals of all races are denied equal opportunities. And yet that is the consequence of the district court's decision. It forbids school districts from taking a look at the racial demographics of the students who are taking advantage of a public resource that they're offering. And then when they discover that there's a problem with equal participation, taking measures to rectify those barriers to equal participation, and that
Foster,
simply
doesn't
can't
it
be
even-
the law.
So this is the example I thought of. Doesn't it suggest that the Commonwealth of Massachusetts would have been forbidden from repealing the veterans preference at issue in Feeney? Because say they noticed, turns out this veterans preference overwhelmingly benefits men and prevents women from getting jobs in state government. So we're going to get rid of it in part because of that. And we're not going to have a pro-women policy. We're going to just have a policy that says no more veterans preference. Why wouldn't men in Massachusetts have been able to make precisely the same argument the coalition makes here?
That's exactly right, I think, Your Honor, and I think it underscores why that can't possibly be the right decision. It can't be the case that every time a public entity declines to, adopt a policy that would be, if there's a policy, it goes both ways. If there's a policy that is inequitable, a public entity needs to be able to address that problem and rectify it if it discovers a barrier that it wishes to fix, as in Massachusetts. It goes the other way as well. If a state or a public entity already has policies that it deems to be equitable and ensuring that they ensure equal participation by individuals of all races, it wouldn't make sense to apply strict scrutiny each time that public entity decides not to adopt some kind of proposal that it views as denying equal opportunities. That would simply make no sense. There's a degree to which there's a baseline problem here, which just underscores yet another problem with the coalition's argument. I just wanted to briefly address the racial balancing issue as well. I think there are different definitions of racial balancing going on here. The racial balancing, as the Supreme Court has defined it, is a preference for a specified percentage of a particular racial group merely because of race. And as Mr. Burley was just explaining, most race-neutral policies simply aren't designed to achieve any particular.
Do you agree that racial balancing, as you just defined it, can be a purpose and not just a manner of executing a plan? I was confused in the briefing whether you were saying that racial balancing is only about the way the plan is designed, right? You can never have a facially neutral plan that's designed to racial balance. Or do you agree that you can have a facially neutral plan that has the purpose of racial balancing as you define it?
So we think that, as a matter of fact, most race-neutral plans aren't going to have that purpose. That's because most of them are designed to achieve a lot of different kinds of purposes. They also typically rely on factors that, by their very nature, are not correlated perfectly with race. You could imagine perhaps a hypothetical race-neutral plan that is actually capable of achieving particular numerical benchmarks. Here, for example, you could imagine if the school board had adopted a lottery that could potentially be designed to achieve particular numerical benchmarks, but it still would not be racial balancing, as the Supreme Court has, I'm sorry.
I was just going to offer a hypothetical, but again, it's not what's happening here, but geographic lines, right, are an example of facially neutral factors that are used to set policies that can have intended racial balancing effects, right? We see that in cases in a different context.
Right. Well, they can at least affect racial demographics. Again, it's not.
And they're often done for that purpose.
Exactly. And the Supreme Court, though, has sanctioned that over and over again. We have, Justice Kennedy's opinion in Parents Involved sanctioning drawing school attendance zones with racial demographics in mind. That opinion was cited favorably in inclusive communities by the whole court. So we have multiple examples where the Supreme Court has sanctioned that. I won't go through them all. They're all in our brief. But I do want to make a critical point about a school district that does, if I have time, I see that I'm over, but a school district that does adopt a race-neutral policy that is capable, perhaps, of attaining a particular numerical percentage. Even then, the policy would not be racial balancing as the Supreme Court has defined it, because that racial balancing, as the Supreme Court has defined it, is a preference for a particular percentage merely because of race. So for example, in Croson, the Supreme Court said that the 30% set aside for minority-owned businesses was problematic because it wasn't correlated with what we would expect in terms of the number of minority businesses that would be participating in the market. But when you have a public entity or like a school board that is trying to decide how, if it's distributing a public resource in an equitable way, in a permissible way, it's evaluating who's taking advantage of that resource. It makes perfect sense, and it should be permissible for that school district to take a look at the demographics and look at who is taking advantage of that resource. Does it reflect the racial demographics of the larger relevant community? And when it identifies significant disparities, the school districts need to be able to address those disparities, removing unnecessary barriers to equal participation.
Thank you very much.
Thank you.
I appreciate your help. And Ms. Wilcox, you represent the board? No, you represent Coalition for TJ,
Yes, Your Honor.
the other side of the board.
They're the board.
Good to have you with us.
Thank you. Good morning, and may it please the court. My name is Erin Wilcox, and I represent the Coalition for TJ. Racial discrimination by proxy is nothing new. It's been on the Supreme Court's radar since Yick Wo, and courts have had an analytical framework for rooting it out since Arlington Heights. The district court applied that framework to the undisputed evidence in this case and concluded that the Fairfax County School Board changed the TJ admissions policy in order to disproportionately burden Asian American children. There's no reason for this court to disturb that ruling and continue to subject hundreds of Asian American children to an application process that discriminates against them because of their race.
So you want us to affirm the district court?
We do, Your Honor.
Do you all still subscribe to the proposition that you want to increase unrepresented minorities at TJ?
I'm sorry, Your Honor, could you repeat that?
Do you all, that's your client, continue to support the proposition that you want to increase the numbers of unrepresented minorities at TJ?
Are you referring to the coalition's second look plan, Your Honor?
Well, let me try this. J2368, the coalition said in a deposition, quote, "We all support increasing diversity of Black and Hispanic students at TJ." That was your client that said that in a deposition. Does your client still believe that's correct?
Of course, Your Honor. Our client supports equal opportunity.
No. I didn't ask if you supported what you call equal opportunity. I asked if you support increasing diversity of Black and Hispanic students.
As long as that does not adversely impact and make it more difficult.
You made a proposal. You made a proposal to the board that's in the record here that's called the Second Look program, would materially increase both the geographic and socioeconomic diversity at TJ. And you wanted to increase unrepresented, right? The unrepresented minorities. You said that was your proposal. It related to an earlier proposal before the board. I understand that, but did you all urge them to do what you're now challenging that they did, basically, or claiming that they did?
Not exactly,
So that
Your Honor.
you're speaking with what they used to call, back in the Indian Wars, a forked tongue. You take one position, and it smacks of judicial estoppel or administrative estoppel or something. That you take a position and then you when another proposal adopted that does pretty much what you wanted or said you wanted, you challenge it and say it violates the Constitution of the United States.
No, Your Honor, we disagree with that.
People don't like to be
strongly.
treated that way.
Your Honor, the second look proposal was first a compromise that the board or that the coalition was putting forth to the school board in an attempt to stop them from the obvious discrimination that they were headed towards against Asian American students. That was made clear from really the very beginning in the summer of 2020 that was the direction the board would be heading, was attempting to have fewer Asian American students at TJ to make room for more Black and Hispanic students. That's clear in the record from the statements that the board members and other senior staff in Fairfax County Public Schools made. The Asian American students were in the way. They needed to clear out room to increase the numbers of Black and Hispanic students.
Ms. Wilcox, can I just ask, I don't think I got an answer to this question. I'm going to read this sentence again, and I'm going to ask you yes or no, does your client still agree with this sentence? Quote, "We all support increasing diversity of Black and Hispanic students at TJ." Does your client still believe that?
Yes, Your Honor, but not if it limits opportunities for anyone based on their race.
Okay, so then I want to ask you about something else, which strikes me as the crux of the district court's reasoning, where the district court said the board's policy was designed to increase Black and Hispanic enrollment, which sounds an awful lot like what your client said it endorsed, which would, by necessity, decrease the representation of Asian Americans. How is that possible to square with Feeney?
Your Honor, we're in a zero-sum environment in a school like TJ, and so
In other words, it's not possible to increase the representation of one group without decreasing the representation of another in this zero-sum environment, you're saying?
Yes, Your Honor, that's the very definition of a zero-sum environment.
So that means that any attempt to increase the representation of one group, in your view, by necessity discriminates against another group, by necessity triggers strict scrutiny.
No, Your Honor.
Why not?
Let's think of this like a scale. Can you intend to put a weight on one side of a scale without intending that the other side will go up? No, that doesn't make any sense. So in a zero-sum environment, can the school board intend to change the demographics, increase the representation of one group without necessarily taking away seats from the group that it believes is overrepresented?
All right, well then let me ask you this. How could, because again, you've said that you support the goal of increasing the diversity of Black and Hispanic students. How could the board achieve that goal in a way that you don't think is unconstitutional?
Your Honor, it could take any number of steps that do not disproportionately burden one race. It could, for example, enact a lottery. The board rejected a lottery because they said, as board members quoted in the record, that's not going to give us the diversity we need. It could offer free test prep if it's going to maintain a test. It could get rid of the TJ Magnet program altogether and make it just a regular high school. But any step that it takes that does not disproportionately burden a group of students because of their race would pass constitutional muster.
So let me ask you the question I asked the federal government then. If the Commonwealth of Massachusetts, having won Feeney, decides, thank goodness the Supreme Court said it wasn't unconstitutional to have a veteran's preference, but they kind of raise good points that this really, really, really disadvantages women and results in almost no women working for the Massachusetts state government. So let's get rid of the veteran's preference. Why can't a class of men in Massachusetts challenge that on equal protection grounds that are literally identical to the one you're bringing here?
Because eliminating the veteran's preference for everyone, which eliminating it for men and for women, treats everyone equally.
But that's what the board did here. They eliminated the tests for everyone. They changed the GPA for everyone. They eliminated the application fee. The policy on its face is exactly the same as to everyone.
Yes, Your Honor, but then they implemented a 1.5% middle school allocation and bonus points for experience factors that were precision. They were strategically targeted at eliminating seats that were given to Asian American students, and they did in fact have that effect, spectacular effect. They dropped 19 percentage points in 1 year. So they went beyond simply eliminating a test for everyone, eliminating an application fee for everyone. They then implemented measures that did not treat all students equally based on their race.
So are you conceding that if it wasn't for this 1.5% per school, you would think this plan is constitutional? I rather suspect you would not.
No, Your Honor, the 1.5% allocation as well as the bonus points that are awarded, the experience factors in the policy, those all combine to treat Asian American students unequally compared to other students. So, Your Honors, another aspect of the Arlington Heights inquiry, obviously this is a facially race-neutral policy, no one disputes that, but contrary to what this board would like this court to believe, that doesn't end the inquiry. A policy is not race-neutral, it's not non-discriminatory just because it says it is on its face. And it's not non-discriminatory just because it claims to help some groups of people.
So what you say is that the resolution that says it's race neutral was false, that the board approved a false resolution.
Your Honor, the entire point of Arlington Heights is to look beyond facially race-neutral laws or resolutions and get at what
Adopted
the,
that, I think, 10-1 or something.
I'm sorry, Your
The
Honor.
board adopted that by like a 10-1 vote. They say they adopted a resolution that says race neutral. And you say that's a falsity.
In this case, Your Honor, that resolution is not race-neutral. As we know, based on the district court's analysis and analysis of the facts in this case, that resolution, that policy does in fact discriminate
They
against
didn't
Asian
study
American
to see what
students.
the effect of it was going to be on race basis beforehand, did they?
Your Honor, they did modeling on a previous,
No, that was another proposal. I'm
Sure.
talking about on this one, the one they adopted.
yes, Your Honor, but the board, when they made that decision, when they voted, I believe all but 2 people voted in favor of that decision, they had school-level data on TJ applicants by race and who would receive, who would be, well, they had school-level data on race and who would be eligible for admission to TJ. And so they had all the information they needed. They had previous modeling that was eerily accurate to what they ultimately happened, and they also had all the data they needed to make that decision.
But wait, wasn't that modeling for a plan they didn't adopt?
It was, Your Honor, but it was
So you're
still,
saying we can infer they intended to discriminate because they had data for a plan they didn't adopt and no data for the plan they did adopt?
they did have data for the plan they did adopt, Your Honor. They had data and
But the modeling you're referring to is for a plan they didn't adopt.
the pie charts were for an earlier version of that plan. The school-level data and eligibility and broken down by race and eligibility was applicable even, it's just applicable at school-level
Can I ask you
data.
another question about how intent and impact intersect here? Do you think that under our precedent, when you have a facially neutral policy, I'm not talking about a facially race-based policy, when you have a facially neutral policy, can you state an equal protection claim without having discriminatory impact?
I'm sorry, Your Honor, could you repeat that
Sure.
question?
So again, I'm not talking about I'm not talking about a students for fair admission type plan. I'm talking about a facially race neutral policy. In that bucket, to state an equal protection claim, do you need disparate impact in addition to discriminatory intent?
Your Honor, in this circuit, you do not need a great deal of disparate impact. If you look at McCrory, the court in that case said there was surgical precision, and the disparate impact they found in McCrory was not gigantic. But it's certainly one of the Arlington Heights factors along with.
But I'm not asking if it's one of the factors. I'm asking if in this circuit you have to have at least some. And when I look at Raymond, it seems to pretty much flat out say, I mean, I'll just quote it. It says, to prevail on the merits of their challenges, the challengers had to prove that the law was passed with discriminatory intent and has an actual discriminatory impact. Do you agree that that's the law of this circuit?
I'll agree that that's the law of the circuit, and I will argue that we have shown plenty of discriminatory intent, disparate impact in this case.
Can I ask you then one question about something I noticed in your briefs? So in your briefs, you repeatedly say that the board's goal was to decrease enrollment of overrepresented Asian Americans, and over again in your brief, you put that word in quotes. And then I started wondering where that word comes from, and I don't see anywhere in the joint appendix where the board used the word overrepresented to refer to Asian Americans. Usually when your brief does it, there's no citation whatsoever for where that language comes from. Could you point me to a single instance in this record where the board mentioned overrepresented Asian Americans?
I'm not aware of one, Your Honor. I'm sure if we find one, we can let you know. But I believe that we're using overrepresented in quotes because we don't believe that a group can be overrepresented.
So those scare quotes you're not asserting are the board's scare quotes. Those are your scare quotes around overrepresented.
Yes, Your Honor. Yes, Your Honor. And Your Honor, just
They're
to,
there for argument purposes.
yes, we are arguing in that brief, and we are arguing that a group cannot be overrepresented.
Lawyers can do that. Go ahead.
We love our scare quotes, Your Honor. Your Honor, just to circle back a little bit to the question of modeling on the previous plan versus modeling on the plan that was adopted. Your Honor, there has never been a point system, this experience factors point system, in the TJ admissions policy before.
Modeling was what, on the first proposed plan?
Yes, sir, it was in the
This was
September plan.
And this, the one that's adopted was the fourth proposal,
Yes,
and the only one adopted.
yes, that was the plan that was adopted in December. So there wasn't a points plan previous to that. That was something that
They studied it over, a few months. The studies and the discussions went on for a period of time.
Yes, Your Honor. The discussions went on. They started in September. September, I think, 15th was when the first presentation was made to the board by the superintendent at that time. The board voted in December 17th. So it was a fairly quick process, all things considered. And, you know, I will talk a little bit about, in my quickly diminishing time, how unusual that process was. And as the district court pointed out, it was rushed and shoddy are the words that he used.
What's the relevancy of all this prior stuff? Don't we have to focus on what was adopted and what they did in adopting it? What it says?
Your Honor, it all informs the process or the policy that was ultimately adopted. And it starts back in the summer of 2020 when race was in their minds from the forefront. Race was in the minds from the minute that the admissions numbers came out from that year in June of 2020. George Floyd had just been murdered. These admissions data came out. There was uproar. There were board members promising intentful, impactful action, saying that the admissions numbers for TJ that year were not good enough and they were going to take action to change it. And it developed from there.
They had, 18 out of 26 junior highs that weren't represented?
I believe that's the correct number, Your Honor, but that's because several of those schools.
That would be they would have been the underrepresented group. Those schools.
Some of those schools would have been, Your Honor, because many of them were not feeder schools. They were not advanced schools.
If there's such a thing as representation, meaning somebody's there, if 18 of them have nobody, the 18 of them are underrepresented.
Well, Your Honor, I don't believe 18
And
of
they
them.
adopted the, 1.5% possibility or something, right?
I don't believe 18 of those schools had nobody, but they didn't send as many students as the advanced academic centers, which drew students from their neighborhoods into these concentrated
I thought they came from like 8
schools.
of the 26 schools of the junior highs or something. But anyway, you go ahead. I don't mean to.
Well, Your Honor, I'm out of time, I see, so unless there are further questions, we would urge this court to affirm the
I had
district.
one.
Yes, sir.
So, Ms. Wilcox, I agree that under Arlington Heights, a rushed and shoddy process is a factor the Supreme Court has said we've had to look at. It is my sense, and I'm genuinely asking this, it is my sense that when the courts have talked about a rushed and shoddy process, they're usually talking about, like, a plan is announced and, like, they vote the next day. My sense is, I totally understand that your clients would have preferred this process to be longer, but my sense is that a multi-month process with multiple white papers is not exactly in the heartland of cases where courts have referred to the rushed and shoddy process. What do you think is the closest case to this one where courts have relied on that factor, the rushed and shoddy process? The ones I'm thinking about are like, we announce the text of the bill and we vote that night, or we announce the text of the bill and we vote 2 days later. What's the closest to the facts of this case where a court has relied on that factor?
Well, Your Honor, in our briefing, we're not arguing necessarily the time. I know the district court said rushed and shoddy, but what we're taking issue with in our briefing is lack of transparency that even board members, let alone the public, are saying, we don't know what's being voted on. When the board eliminated the TJ test in October, nobody knew that was
That's maybe an argument that they could have done this better as a matter of sort of administrative procedure, but I guess under the Equal Protection Clause, the reason rushed and shoddy process would be relevant is as indirect evidence that they were doing something nefarious or with ill intent. And I'm trying to think of a case that basically relies on, I wish it would have been more transparent, I wish it would have been more thorough, where a court has said that is evidence of an unconstitutional intent.
Yeah, Your Honor, I think we're going to stand probably on McCrory, but really on our point that it's not as much.
But then in McCrory, the text of the bill was announced 3 days before it was voted on.
That's true, Your Honor. I really just want to point to, as we say in our briefing, just the lack of information, the fact that, there were more meetings held to rename 2 schools than there were to change this admissions process for this elite high school in Fairfax County. So that's really, I think, where we're at in the rushed and shoddy process.
Thank you very much, Ms. Wilson, Ms. Wilcox. We appreciate you. Mr. Ferguson? You represent the Commonwealth of Virginia?
That's right, Your Honor, and 15 other amici states.
Good to have you with us, sir.
Thank you, Judge
You
King.
mean 15 others have joined your amicus brief?
Pardon me, Your Honor, I'm
You
sorry.
mean there are 15 other states have joined your amicus brief?
That's right, Judge
We
King.
have another group of attorneys general on the other side. What's their number?
I think it's around the same. It's safe to say the country's split on the issue.
We got lots of states attorneys general filing papers here. We appreciate it, though.
That's right.
And it's good to have you here.
Thank you, Judge King. Good morning, and may it please the court. I would like to address one limited issue in my time this morning. This appeal will turn in large part on how to measure whether the school board's new admissions policy had a disparate impact on Asian American applicants. The amici states have an important interest in the resolution of this question, given that all states play a critical role in guaranteeing the application of the 14th Amendment in their schools. The amici states agree with the coalition that the proper impact analysis in a case like this one can be to compare the rates of offers made to Asian American applicants before the new policy was implemented and the rates made after, for 3 reasons. First, it's consistent with the anti-circumvention principle that Arlington Heights embodies. Second, the school board's parade of horribles about this form of analysis are overwrought. And third, it's consistent with McCrory. Beginning with anti-circumvention, the Equal Protection Clause requires that the state treat the citizen as an individual and not as a component of a racial group. It therefore prohibits laws that have the purpose of discriminating on the basis of race. That guarantee would mean very little if it were limited to laws where the purpose appeared exclusively in the face of the statute. Arlington Heights and McCrory serve a critical anti-circumvention function. They prevent the government from making decisions motivated by discriminatory purpose, irrespective of whether the purpose appears on the face of the statute. The disparate impact prong of Arlington Heights should be interpreted in light of that anti-circumvention principle, and we think that it favors the coalition's position. The 14th Amendment forbids schools or school boards or any educational institution that wants to promote diversity from trying to promote diversity by seeking a particular number or quota or aiming for a particular number.
Mr. Ferguson, can I ask you the same Feeney hypo I asked 2 other people? Under this theory, why wouldn't it be a constitutionally disparate impact if Massachusetts eliminated its veterans preference?
Because disparate impact would not itself be sufficient to establish the 14th Amendment.
Okay, so in your view, there would be a constitutionally relevant disparate impact, though. That class of plaintiffs has stated the disparate impact element in your view.
I think it would be relevant to the analysis of whether the enacting legislature was motivated by an invidious purpose. And I don't think that's particularly surprising. And if I can just jump to the McCrory issue very quickly. McCrory, with respect to my friend on the other side, McCrory didn't hold that this sort of analysis was forbidden. It said it isn't required to state an invidious purpose claim. Because as Judge Rushing said earlier this morning, in McCrory, Black participation rates in subsequent election went up by 1.8%. And the district court held, well, clearly there couldn't have been disparate impact because voter participation went up. And the court said that's far too onerous a burden to require a party to show disparate impact. But it doesn't follow from that that can't establish disparate impact. It might not be necessary, but it is certainly relevant. And I think that that's the problem with the argument of my friend on the other side, is their argument is that the 14th Amendment excludes consideration of the status of one racial group before a policy was changed and afterward. That simply can't be correct. It sort of defies common sense. And so I think that the importance of interpreting that way is to keep it consistent with Arlington Heights. The point of Arlington Heights is you can't do tacitly what the Constitution forbids you from doing expressly. And I think there is a danger. It wouldn't apply in every case because we're talking about purpose, which is a sensitive multi-factor analysis, as the court said in Arlington Heights. But we run the risk if we say that it is constitutionally irrelevant what was going on before a policy and after the policy change, that states could hide attempts to use quotas or attempts to achieve racial balancing in facially neutral language. And as long as they kept their quotas underneath the proportion of the population, under this analysis, they would be fine, irrespective of what happened after the policy change. And I simply think that that can't be correct.
Mr. Ferguson, does the Commonwealth of Virginia and those other 15 states think the Texas 10% plan is unconstitutional?
2 responses to that, Your Honor. First, the 16 states represented here do not take a position on it. And second, I don't think it's relevant here because there's no doubt that the Texas top 10% plan was facially neutral, so it would be subject to the Arlington Heights analysis.
There's also no serious doubt in the world, as a person who was alive when this happened, that it was enacted in significant measure to prevent Black and Hispanic enrollment at the University of Texas from collapsing in the wake of Hopwood. There is no serious argument that that was not one of the things the Texas legislature was trying to do. Do you contend otherwise?
Judge Heintz, I was also alive during the top 10%, but I will defer to your view on that. But it was unequivocally a part of Justice Kennedy's opinion in Fisher 2 that for reasons that aren't clear from the record, the plaintiff had decided not to challenge the top 10% plan, and so no one addressed it. And with respect to my friend on the other side, the brief references to it in Justice Scalia's and Justice Thomas's dissent did nothing approaching an Arlington Heights analysis, and I just don't think it tells us anything about whether it's constitutional, and certainly the amici states don't take a position on it today. I see that my time has expired, so unless there are additional questions, the amici states ask that the judgment of the district court be affirmed. Thank you.
Thank you, Mr. Ferguson. Mr. Varelli?
Thank you, Your Honor. A few points, if I could. I want to start with the experience factors, which the coalition raised as an implementing force for this discrimination. There's only one experience factor that they identify in their brief, and only one on which the district court relied, and that's the underrepresented schools factor. I think it's worth looking at the facts of that because I think it exposes what's really going on here. Now, the underrepresented schools factor, by definition, applies only to the 100 unallocated seats in the system, because if you're going to an underrepresented school, 100% of the people get the credit for it. If you're not, 0%. So in competition for the 1.5 seats, it has no relevance. It applies only to the unallocated seats. Now, there were 88 unallocated seats in the year challenged here. 81 of the 88 went to students in the feeder schools, in other words, not underrepresented schools. So we're talking about 7 students. We don't even know the race of the 7 students. They could all be Asian American for all we know. The district court described that as a significant discrimination against Asian Americans. And with all due respect, it's ridiculous. We're talking about 7 students. And we've gone through with respect to the other factor, the 1.5% factor that they've relied on, and we showed in our brief that there are many, many non-feeder schools that have comparable Asian American percentages to feeder schools. And what this gets to, I think, is a fundamental point with respect to the argument they're making even about disparate impact, is that even if one were to concede that disparate impact year over year of the kind that they are arguing for is relevant in this analysis, you have to show it by statistically significant proof. You have to isolate out the factors you're challenging and demonstrate that they were the causative element. That's what the Supreme Court said in Watson. That's the law in this area.
Isn't Watson a Title VII case where you can make your entire case just by showing disparate impact, right? There's no requirement of additional factors to show intent. Is a different standard or a less onerous standard for disparate impact applicable in equal protection context?
So what I guess I would say about that is that you haven't proved disparate impact unless you have shown it by statistically significant evidence, whether it's for Title VII and dispositive or in this context and relevant.
And certainly, I'm just curious about, you talk about in your brief about eliminating the other factors and showing causation and all the analysis that's necessary. And, that's certainly not what we required in McCrory. And I haven't seen that in the equal protection jurisprudence because there's other evidence of intent. Now, certainly you see that in Title VII because you can have a standalone disparate impact claim. And I wondered if your position is, which it seems to be, that the requirements for a standalone disparate impact claim apply to a discriminatory intent claim under the Equal Protection Clause.
I'm going to say it a little differently. I'm not trying to dodge Your Honor's question, but I think you have to prove causation. And if you haven't got statistically significant proof, you haven't proved that the thing that you're complaining about caused the result that you claim is discriminatory.
Did the McCrory plaintiffs have statistically significant causation proven?
So I don't know whether they did or not, Your Honor.
Did the court mention it?
No, Your Honor, but I think in this context, when what you are talking about, what they're claiming is 2 things, 1.5% and the underrepresented schools factor, caused the drop in the Asian American numbers, as opposed to, say, the massive increase and change in the demographics of the applicant pool, 900 more people, different. They didn't prove what they set out to prove here. I think that's the key point. If I could, just a couple of other points before I wrap up. One is, in terms of this, there's one really salient fact, and I want to make sure it doesn't get lost here. The argument here is that this plan intentionally discriminates against Asian Americans. What this plan, in fact, does is remove socioeconomic and geographic barriers that affect people of all races, Asian American, African American, Latino, white, mixed race people. And striking proof of that is this undisputed fact. In the year before the adoption of the new plan, one low-income Asian American was admitted to TJ, one. In the year after, the number was 51 Asian Americans. Now, I point out, that number is higher, the 51 low-income Asian American number is higher than the total number of African Americans admitted under the new plan, which is 39. And it's very close to the total number of Latinos admitted under the new plan, which is 62. So I think that should give the court a little perspective on the allegation that what this plan was designed to do is discriminate against Asian Americans. What this plan was designed to do was to remove socioeconomic and geographic barriers that held back people of all races, including African Americans and Latinos. So that was one purpose, and we don't deny it. But it benefited all races. And so I think that tells you what you need to know about whether or not this was a plan that was adopted for the purpose of discriminating against Asian Americans. Thank you.
Thank you, Mr. Varelli. The case will be submitted. We very much appreciated the arguments of counsel. It was good to have you here. If we were operating under normal rules, we'd come down at this point and visit with you at the well of the court. But we're not going to do that today. We'll do that next time. Good to have you here. Madam Clerk, we'll set up for the next case. Et al., number 21-1764. Mr. Wilkins, good to have you with us, sir.
Thank you, Your Honor. My name is Billy Wilkins, and at council table with me is Colin Ram. The Supreme Court in the Alton decision described the NCAA and its university and college members as a massive business enterprise in which everybody associated with it, including Adidas, which is a financial sponsor of the University of Louisville, made millions, indeed billions of dollars. And it was also a business, the Supreme Court said, that would be flatly illegal almost anywhere else in the United States because the laborers, the student athletes, were unlawfully restrained. So why would any high school superstar athlete like Brian Bowen even consider offering his labor and his talents at great personal sacrifice to go to a Division I university and play basketball there? Well, it's because early in his life, encouraged by his coaches, he decided to pursue a career as a professional basketball player in the NBA. And to pursue this career realistically, there was only one place to go. That's the University Division I basketball teams. As the Supreme Court recognized in Austin, the NCAA is the only, and I quote, relevant market for athletic services in men's and women's basketball. There is no viable substitute.
Mr. Wilkins, do you agree that your client, he received all the compensation he could possibly get when he was participating in that market? When he was playing or eligible or even not eligible, but still in college, he received the maximum compensation he could receive as a college athlete.
He did.
Your argument's about his hopes that it would lead to a professional career.
Well, that's the ultimate goal, but his hope was to obtain what he was entitled to under his athletic tender agreement. That is, to the best coaching could be offered in the United States anywhere, the best athletic facility, the best conditioning, the best physical training, the best nutrition, all of those things that were stripped away from him because of this bribe that was paid to his daddy.
Mr. Wilkins, let me ask you about that, because I agree. It seems that he expected for that, he hoped for that, he maybe even thought it was far more likely than not. But let me ask you this. Say he gets to Louisville, and they don't pull a scholarship. They allow him to attend Louisville. They honor his scholarship, and they say, you know, we're not going to give you those things for whatever reason. Could he have sued the University of Louisville for breach of contract?
You know, actually, I think he could have. It would not be realistic to think you would sue your own coaches, but realistically...
What authority, because I looked and I couldn't find it, but maybe what authority under Kentucky law suggests that he could have maintained a viable suit against the University of Louisville, who, again, in this hypothetical, is giving him his scholarship, he's enrolled at Louisville, excuse me. But, you know, if he sued them for breach of not coaching or breach of nutrition or breach of all these other benefits, what authority do you have for the proposition that under Kentucky law he would have had a viable breach of contract claim against Louisville?
Just like a business license issued by a county or a city, or a pilot's license, commercial issued by the FAA, or a recognition of de facto tenure by a college, or a certificate of eligibility that he had. This entitled him to certain things. When he signed, because of that eligibility certificate, he was able to accept and did accept that athletic tender agreement.
Well, I understand that sometimes people are entitled to benefits that are not expressly written down, but that's a matter of generally state law. What is the authority for the proposition that these types of benefits would support a breach of contract action under Kentucky law?
And he had an entitlement under Kentucky law, in fact, every state just that I know of, and in federal law. He had an entitlement, and that entitlement...
I mean, he can assert anything he wants, but what is the evidence that he has a legal right that would be recognized in Kentucky?
He had an entitlement based upon the policies and the practices and traditions to receive these things that he agreed to give his labor for. And if it was denied him improperly, he could bring a lawsuit against the University of Louisville or whomever denied him, in this case Adidas, of that right. Now, I realize, Your Honor, that
You aren't suing under contract.
No, sir.
You're
We're not
suing under RICO.
That's right.
You're suing under RICO. That's what we're faced with here, is whether it's a RICO case, but Judge Anderson threw it out on standing, didn't he?
Yes, sir. That's right.
That's the big issue here.
That is the issue. He had an entitlement, and it was stripped away from him because of the bribe that was paid to his father.
The district court says he doesn't have standing to sue.
He said that did not have, because the district court did not understand.
So how's that error? That's what we got to figure out.
Well, it's error because the district court said, well, he got his scholarship. He's still at Louisville. He could have stayed there for 4 years, I guess, but he left after one semester to try to pursue best he could his athletic career. But the scholarship was not what was at issue here. He could have gotten that same scholarship from 50 universities because they all offered the same scholarship. He didn't go to Louisville because of the outstanding chemical laboratory of the math department. He went there because he was entitled to the best coaching. He was promised the best coaching. And all of those other things that the NCAA says, these are
We're kind
called...
of back to the contract then, and there is a contract, and it's written down, and we're supposed to look at the contract and see what each side agreed to. Now, there might be evidence outside the contract about, you know, they tried to get me to come by saying I was going to get the best coaching, I was going to get early minutes. But the contract says that we will give you tuition, and we will pay for all of these things, and you will come, you will come to our school. Why am I looking outside the contract to figure out what his property is in the contract?
Well, there was no integration clause in this contract, period. Number two.
Does that mean, under the law, just because there's an integration clause, I can look outside to what any external evidence of intent was?
Yes.
I don't think so.
I do. Yes,
If the contract's unambiguous, we look at the contract.
The contract, we look at tradition, we look at the intent of the parties, we look at what has gone on in the past, we look at custom to see what was implicitly understood by the parties. And there is no mistake here, really, Your Honor, that it was understood by Bryan, Louisville, the coaches, indeed the NCAA, that these are the things that he would receive, because that's what these schools, Division I schools, bargained with. We got the best coaches. We got a $237 million facility. We got the best nutritional program. You need to gain at least 20 pounds, but not fat. You need muscle. We got this nutrition. But that's how they sell the school. And so it's implicitly implied, indeed.
Is that all called parole evidence in the context of this case? Beyond the terms of the contract?
Absolutely. Absolutely. And in fact, you look at the NCAA bylaw.
Well outside the specific provisions of the contract and prove all this other stuff.
Well, absolutely you do, because if you got a contract that does not have an integration clause, you can look to tradition. What was the intent of the parties? Indeed, you look to the NCAA bylaws.
To make a RICO out of it, you got to have a bunch of predicate acts which constitute crime.
Well, that's right.
And what are your predicate acts that you'd prove here?
The predicate act here was when Adidas facilitated the payment of a bribe to his daddy. And that led directly to him being declared in a state of being recognized as a state of...
What are the federal crimes that arise there? Mail fraud or wire fraud?
That's right, mail fraud, wire fraud, all of that. And that's not really an issue before the court. It's not contested here. That happened.
They falsified the records at Adidas to cover up the payments?
They did.
Can I go back? We've been talking about...
we're just talking about this one fella. This looks kind of bad for the college basketball programs. Go ahead.
Can I ask you, so we were talking about rights that he may or may not have under a contract, but of course RICO doesn't refer to injured in your contracts. It says injured in your business or property. And I see a lot of discussion in the briefs about what property does and doesn't mean, but very little discussion of what injured in your business means. Could you tell me, what does your client think an injury in his business means, and why does your client satisfy it? Or are you relying solely on the word property? I guess that's the other question. I'm just trying to parse out business versus property and what they do and mean and where they overlap and where they don't.
His certificate of eligibility that was issued to him was his key to open that door to Division I basketball. And with that came that athletic tender agreement that provided all of these benefits.
Sure, and in the language of RICO, is that key, is that a business key or a property key? Because RICO doesn't say injured in your key, it says injured in your business.
It's hard to make the distinction. Is it a business or a property? It certainly is a property interest that he had. Just like an FAA pilot's license or a business license issued by a county. It is something that he had that was the only thing that could open that door for him to pursue that career. And it was a property interest. Indeed, Adidas's president testified in his deposition. Yes, he said, I acknowledge that a certificate of eligibility has significant value, to use his words. And that's what this young man had. And it was stripped away.
Do you think that anything that has significant value is business or property under RICO? I can think of lots of things that have value that I wouldn't necessarily think of as business or property.
Well, there may be value in many intrinsic ways, I guess, Your Honor, and I don't disagree with what you say, but this had real value in terms of making a lot of money, and that's what the experts said. Stephen Bratz, he's been the NCAA for over 36 years as a player, as a coach, as a scout, as a personnel professional evaluator, and he testified in his opinion, if this certificate of eligibility had not been stripped away from Brian Bowen, he would have been 2 years out, a first choice NBA draft choice. He would have gone and he would have been either between 16 and 21. And if you look at the pay chart, now this is all.
Does the certificate of eligibility, though, have independent value as business or property apart from converting it into a contract? You know, you have to maintain eligibility from a young age, right? There are high school students who are maintaining their eligibility, but a lot of them don't have what it takes, right? It means it's valuable, but it's not a business or a property interest perhaps until they turn it into a contract or an agreement to play for a certain school, or I think there might be a connection there that, you know, is that eligibility valuable? Is it business and property by itself, apart from the contract?
Well, I think it is, Your Honor. I mean, it's the key. If you don't have this key, this certificate of eligibility, you can't get in the door. The door is shut.
But it's not enough by itself.
No, but that certificate, just like the FAA issues a commercial pilot's license, that license itself sits in his desk, but it gives him the right to go to that commercial airline and get a job and fly that commercial plane, just like this certificate of eligibility. Put him in that very rare category of students, athletic students, young high school students who can go into a Division I school with a 4-year no-cut contract, be guaranteed all of these things to increase his athletic ability that would springboard him to be a #1 draft choice, according to the experts. And by the way, that's undisputed. Adidas offers no testimony that had this eligibility not been stripped from him, he would have been a first choice draft choice, first draft. And
NCAA schools are what the farm teams for the NBA. Is that what?
Yes, sir.
That's the structure of it all?
In fact, you can't get to the NBA hardly unless you come from Europe, someplace else, unless you go to Division I basketball team in this country. As the Supreme Court said, they have a monopoly. This is it. You got to go to a Division I school, and you need to play. And of course, the rules require you to stay out of high school for at least 1 year. So you can either sit around or do nothing, or you can play basketball at a top flight school. Of course, everybody who tries to get to the NBA, that's what they want to do. And that's what this young man did. And he took this.
This RICO statute was racketeering, influenced and corrupt organizations, was set up to combat organized crime. It wasn't supposed to be stretched to this kind of stuff, was it?
Well, you know, there's a lot of argument that that's the case, but RICO has been stretched and interpreted much more broadly than even perhaps some of the drafters of this statute visualized. But there's no question here, this is not an issue, that this is a RICO violation, if it is one at all. That's what it is. No one says it's not a RICO for this conspiracy to offer this bribe to his father, to encourage him, to ensure that he went to the University of Louisville. And that was the purpose of the whole scheme, to get this young man who was a top flight student athlete to go to Louisville, not somewhere else, Louisville. and that's where he ended up going, and that's where he gave his labors and said, I'm in return, I want all of these things that you've guaranteed that I'm going to have. Agreed, Your Honor, it was not in writing, but it doesn't have to be. You look to what happened the year before, or 10 years before, or what was happening while he was there for 2 months. He was receiving all of these things. And indeed, the NCAA bylaws enumerate all of these things that he got: coaching, practicing, nutrition, training, physical training, all of these things. And they say to this university, you can't give him more than what we're going to allow. Every day, each student, athlete at Louisville's name is on the board, and the number of hours devoted to coaching, weight training, nutrition, practice sessions, strategy sessions, all of that's enumerated because you can't give them more, NCAA says, than what we say you can, because they know the university will push them to the limit and beyond the limit if they can, because that makes them a better athlete, makes them win more games, more money coming in from the box office. So even though things that are guaranteed are limited.
Let's see what Mr. Taft has to say about this.
Thank you, Your Honor.
Mr. Wilkins, you save some time. Mr. Taft?
Good morning, Your Honor, and may it please the court.
Good to have you here, sir.
Will Taft, on behalf of the defendant police, including our client Adidas America Incorporated, I'm joined here today by Nathan Richards, my colleague. This case presents 4 core questions: whether appellant had a contractual right under a scholarship agreement to a spot on the men's basketball team at Louisville; second, whether he had a right to participate in interscholastic sports derived from some other source; third, whether he had a right to be selected in the first round of the 2019 NBA draft; and fourth, whether any of the injuries alleged by appellant were directly and actually caused by the alleged predicate scheme. Judge Anderson below correctly dismissed this case for lack of standing. The summary judgment was bifurcated, and he was addressing only the standing issue. I say that because the RICO predicate is contested.
So in the standing is the only issue we face?
Correct, yes, Your Honor. Although standing both the lack of an injury to business or property and also the parties have briefed the lack of direct and proximate causation. I just say that because, to be clear, the fact of a RICO predicate having been committed is contested, and if this ever went back to Judge Anderson, there would be summary judgment.
No, but if we ruled that Judge Anderson was wrong and that he has standing, it has to go back.
There's a further phase of summary
You're going to deal with
judgment.
the rest of this stuff. We don't have anything else to deal with beyond standing today.
Correct, Your Honor. So turning to the contract, it's...
Can I just ask you before that?
Yes,
because this is not an area out of background. When we're talking about standing here, this is not like standing. This is just the way that courts sometimes use jurisdiction when they don't really mean jurisdiction. This is just a question about whether he states a claim under RICO,
That's
right?
correct. It's a statutory element of the claim. It can be waived. It is not jurisdictional. And so turning to the contract, it's undisputed that Louisville complied with all of the express terms of the scholarship agreement. There's no ambiguity on the contract, and therefore the interpretation really stops there under Kentucky law. You look at the plain language, and then you stop. What appellant is arguing is that there's an implied right in this contract to be on the team and to receive various basketball benefits. This same argument has been considered and rejected by multiple courts, including Jackson v. Drake University, which involved a Division I basketball player on scholarship who had been told he would be a star, who claimed that he had a right under his scholarship agreement to play, and the court disagreed. You had the same result in Highsaw v. Washburn, University District of Kansas, 1987, involving football scholarship players, and even the case cited in the reply brief by appellant, Brands v. Sheldon, doesn't state that a scholarship gives you a right to play on the team, and indeed acknowledges that there is no general right to participate in interscholastic sports. The proffered distinction between Tinder agreements...
There's a right to try.
Is there a right to try?
Right to try.
Under the
That's what these young men
Yes.
and young women seek to do. and they have a right to make efforts, and they have a right, I would think, to have the people they're dealing with be honest. And there's a lot of stuff in this record that stinks.
Your Honor, looking at the contract, though, as the court 10th Circuit held in Colorado Seminary, the right of a scholarship athlete to play on the team is no more than the right of a walk-on, because the contract doesn't give you a spot on the team. The implications of appellant's argument would be that any time a player gets cut, or any time a coach doesn't run enough plays for the player, or he's asked to play a position other than what he wants to play, he has a breach of contract claim. And again, we don't see those claims because the rights under these scholarship agreements don't exist. There was nothing different about Bowen's scholarship agreement. As Alston pointed out, all the defining characteristic of these scholarship agreements is that players are offering their athletic services in exchange for tuition, room and board, money.
Schools want the best players. The schools want to get the good players to come to them. And under this record, folks are out there paying off the parents to attract the student athletes, and get them there. We're talking about 18-year-olds. As I say, there's a lot of stuff here that stinks.
Those are, again, those are the factual allegations. And for purposes of this summary judgment, we're accepting those as true for purposes of this summary
We
judgment.
take them as true for purposes of this case.
So for purposes of this appeal, true, but does not support RICO standing, because again, no contract right to play,
Well,
no
maybe
general right to
You might be
participate.
right on the legal point. Maybe you're right, but there's a bunch of stuff here that stinks.
I hope I'm right on the legal point. And the courts that have looked at.
RICO was supposed to be organized crime. That's what it's called, or what it was for. I was around when it started.
And the class of private plaintiffs who have causes of action is extremely limited, including by this standing requirement.
Hard to qualify. You have to have all these predicate acts, which have to be criminal acts. And there's a specified types of criminal acts, different statutes. But mail fraud and wire fraud and robbery and those kinds of things are within those acts.
And again, we're conceding for purposes of this appeal on summary judgment that there was a RICO predicate, but only for this appeal. But even so, he can't establish causation
Mr. Taft, can I
or
ask you the
harm.
same question I asked your friend on the other side? I saw a lot of briefing about what property means under RICO, but I saw, candidly, very little briefing about what the word business means under RICO. What does Adidas think business means, and why do you think that he doesn't show? So I'm quite familiar with your argument that he's not shown injury to his property. What is your argument that he hasn't shown injury to his business?
Well, his business, to the extent he had a business as a pre-professional amateur athlete, his business interest was receiving what he was entitled to under his scholarship, which he did. In this case, it would be a room and board.
And why? Because
tuition.
I guess what I'm saying is, when RICO uses business or property, basic principles of statutory construction tell me that business can't simply just mean property. It has to mean something that is a non-complete Venn diagram overlap with the word property. What do you think business covers that property doesn't?
So let me give a few examples. If a company is deprived of the services of its employees because they're being intimidated by a racketeering scheme,
It'd be a pity if your employees didn't show up to work tomorrow, something like that.
Well, there's a National Organization of Women case which involved an alleged scheme interfering with employees at an abortion clinic. And that was held to interfere with the right of that company to the services of its employees. There are cases holding that lost past profits, sort of lost business, that deals that would have happened in the past. American Honda from Maryland finds that, I think it's hard to say that I have a property interest in a sale that I didn't make, but that is a business harm because I have an active operating business. Appellant was receiving everything he possibly could have received in terms of compensation for his tendering his athletic services. He had a max deal and the University of Louisville had told him in writing at JA 751, I believe, that he would be entitled to keep his scholarship if he chose to stay.
So then let me give you that hypo. So this is the hypo that I'm having candidly a little trouble with. So I understand your guy never played a minute of Division I college basketball, and your whole point, I think, is everything is super speculative. Who knows what's going to happen, right? But imagine someone. There was that player at Duke a number of years ago who, like, literally every single person on earth knew was going to be the #1 draft pick, right? Who was drafted by the New Orleans team. And imagine that the week before the draft, a RICO enterprise proceeds to do a series of crimes that are predicate offenses. It's a RICO enterprise. They do a whole series of crimes that are clearly RICO predicates designed to destroy his draft stock 1 week before the draft. Has that person been injured in his business? And if so, what's the categorical difference between that person and this person?
I think it would matter what the causal connection is.
Oh no, he's going to be drafted like literally next week, #1 in the NBA draft, and someone's going to do a series of RICO predicates. I mean, designed to make sure that doesn't happen. They break his leg, or they do an incredibly elaborate libel scheme designed to destroy his reputation and try and tank his draft stock, or something like that.
Again, I mean, the requirement under SLAES for proximate cause is that the injury be suffered at the first step, and that it not just be foreseeable, but really.
Oh, no, the whole point of this RICO enterprise is to destroy this person's draft stock. That's the reason for the RICO enterprise.
Okay. Even then, I would say that his injury is a mere expectation because he doesn't have the contract yet, and he has an expectancy, a genuinely held expectancy, but that is not property. At that point, he.
No, I agree it's not property.
At that point, he may be in the business because he's no longer an amateur.
That's what I'm saying. I've declared for the draft. I've committed myself to a life course.
So I admit it's a closer case because he has declared for the draft at that point, and he is in the process of he would have signed contracts that require him to do certain things with respect to the NBA. But I don't think he can say that he had an entitlement to be selected first. I don't think he could say he had an entitlement to be selected in the first round.
But why does injury in my business require an entitlement? I don't have an entitlement to have customers come into my store, but if a RICO enterprise intimidates all of my customers, I still have been injured in my business, you told me.
If you have an active business at that point, you do have a concrete financial harm. And again, it's looking back to the concrete financial harm, and the closer you get to actually being employed and actually having a contractual right to salary, the closer you get to being able to establish a business harm. I agree that the cases do not spend a lot of time, and it's not, the briefs aren't ignoring cases to my knowledge, as the courts haven't spent a lot of time distinguishing business and property, but we know that mere expectancies are insufficient. We know that hoped for outcomes are not sufficient, and that's both true with respect to defining the business or property interest. Mark Antonio, Western District of Virginia, in 2015 involved a scholarship student who was not able to participate on the UVA swim team. He said, I've got an expectancy, I want to do this for my professional career. And he sued under a Virginia business conspiracy, which had the same business and property requirement. There the court said that your expectancy in your future career is insufficient.
Swimming's not quite comparable to NBA basketball.
Maybe in
what's
dollars.
Adidas into all this for? Trying to sell shoes? What are you trying to market besides shoes?
Excuse me, Your Honor?
Adidas, they're trying to sell shoes?
So
That's what it is?
Adidas is an apparel manufacturing company.
But they're competing with Nike, and you get these, you sign up to college basketball teams because you want to market shoes around the world to young people.
The college sponsorships are part of marketing, and they're part of supporting sports.
And then you get into underhanded activity that contravenes a lot of these statutes that are identified in the RICO statute as predicate acts.
Yes, Your Honor.
They need some lawyers to advise them ahead of time, I would think.
And the question is how far down the causal chain and how attenuated is the harm that is actionable.
Before we, oh,
And this young man is on the end of it. In my view, he's a victim of all of it. A lot of them come from underprivileged areas, underprivileged kids. That's the only opportunity in life.
As Judge Anderson said, there's no doubt that his expectations about how his path to the NBA would unfold were disrupted. But again, he made it to the NBA, and he didn't have a right under his contract or under this court's precedent in equity and athletics, the 10th Circuit decision in Colorado Seminary, to participate in interscholastic sports. I would like to say a word about Alston, given the focus that it gets. Alston is an important antitrust case, but it doesn't address business or property standing at all. It wasn't challenged by the NCAA, and neither the District Court, the 9th Circuit, nor the 10th Circuit addressed it. But the harm being alleged in Alston is important.
So is your hypothesis the NCAA just overlooked a winning statutory standing argument?
If the court had addressed it hypothetically, they would have seen, I think, that the student athletes in that case were asking for money, or at least arguing that the antitrust violation had resulted in them receiving less money for contracts that they had entered into. And again, that is not the harm that appellant is claiming here. Appellant is claiming that he was harmed by not being able to play. But again, we've seen the contract on its face, no right to a spot on the team.
what is your response to plaintiff's argument comparing NCAA eligibility to a business license, like an FAA certificate?
So having an FAA certificate, first of all, I haven't seen any cases sort of drawing that analogy, but an FAA certificate, I would say, is required in order to fly a jetliner, but it doesn't give you a right to a job at an airline, and it doesn't to lose it. I'm not sure that you would have been deprived of a property right. Now, if because you lost it, you lost your job and you lost your salary, that would be a concrete financial harm. But again, appellant didn't lose his salary. He was entitled to keep everything under the scholarship agreement.
So the real problem, the real distinction I'm hearing in this response and in the response to Judge Hyten's questions has to do with the business in which he's engaged. He's currently engaged in business as a college athlete, but he had only an expectancy of being in the business of being a professional athlete.
Yes, Your Honor.
Okay.
And again,
The eligibility certificate, Mr. Wilkins says, that's the interest.
that is, well, again, and courts who have looked at eligibility have found that it's...
You all undermined his eligibility by paying off his father under the table.
Eligibility entitles you to receive a scholarship agreement.
It entitles you to go to school and play basketball.
Well, it doesn't, Your Honor.
Well,
it entitles you to a scholarship, which he got. Every time the case is looking at loss of eligibility, Colorado Seminary...
Be eligible in order to play.
You need to be eligible in order to play, but if you...
Eligible in order to play, that's what it is, eligibility to play.
Well, it's...
You say he might not make a team, maybe he won't, he might get hurt.
He might have played and played badly.
Right.
We don't know.
But he can't play unless he's eligible.
Right, but the loss of that ability to play in NCAA sports is not a tangible, concrete financial harm, provided you're getting everything you're entitled to under the scholarship. Robert Parrish, the chief in the Fifth Circuit, was found not to have a property interest in his future professional career when he was withheld from NCAA tournament games. This court looked at the same thing in equity and athletics, finding that the fact that James Madison University eliminated certain athletics teams, preventing their scholarship athletes from competing on those teams did not implicate property interests in that case.
Were those RICO cases?
Those were not. They were due process cases, but again, courts look at due process cases, they look at state law to figure out the scope of rights protected under RICO. If I can turn quickly to two remaining points. On the NBA draft, it's absolutely disputed as a factual matter, or was, that he would have been drafted had he been able to play in the NCAA. But moving beyond,
He was one of the best high school players in the country, wasn't he?
he was ranked high and had an expectancy of playing, but he admitted that he had no right at his deposition to play. His agent admitted, or started to be drafted. His agent admitted he had no right to be drafted. That's at JA 502 and JA 1230. And they both admitted that there are multiple factors that go into whether or not a player gets drafted.
He was thought by a lot of people to be a real good prospect. That's the reason they were paying off his daddy to get him in school, get him in the right place.
And again, these were expectations. They were not entitlements by his own admission.
They were acts, which they say are predicate acts to federal crimes, to a RICO violation.
So
paying off his father.
that is the allegation. But how far?
Well, it's the allegation, and we take it as true. It's not an allegation for us. It's on this record. It's taken as true.
It's taken as true that it's a RICO predicate.
Taken as true.
But what Judge Anderson looked at was also that payment. What are the direct consequences of that payment? A direct consequence of that payment is not that he didn't get drafted.
Some direct consequences ought to be that some people go to the penitentiary.
And defendants have.
And companies like Adidas clean up their act.
And certain of the defendant appellees have.
Whether this young fellow gets anything or not, but there's something needs to be cleaned up.
So in that sense, the purpose of, there are defendant appellees who were charged, who were convicted, and who are serving sentences, not Adidas. But again, that purpose, that need has been
Well, Adidas shouldn't be falsifying records. They should not be falsifying their records to cover up payoffs.
To turn to, very briefly, and I know I'm over time, an alternative ground of affirmance is the proximate cause and but-for cause. The record shows very clearly and really undisputed that Brian Bowen had lost his eligibility long before the alleged RICO scheme by his father receiving payments from Christian Dawkins and his high school coach. Again, the hearsay objection that's raised in the reply brief was not raised below and is waived. And our opposition brief lays out the evidence that Judge Anderson could have relied on that's undisputed, establishing his lack of eligibility, including the NCAA rules and the unrebutted declaration of Professor Petuto as to how those bylaws apply. Finally, the other injuries with respect to the $750 of attorney's fees that he paid weeks before summary judgment briefing started and years after the services were alleged. The record before Judge Anderson shows that his father paid the attorney's fees, that the attorney was not seeking payment on that 2018 invoice. Clearly, this was a voluntary payment, and the decision after summary judgment was issued to waive privilege with respect to an engagement letter that they had previously withheld in order to support a showing of direct personal financial injury was untimely. Under this court rule in JTH tax, that information was available to appellant. Indeed, they made a decision not to waive privilege and only attempted to introduce it after on a motion for reconsideration. But even the lawyer fees in general, as courts have held, including in Straits Amusements, when you hire a lawyer to remediate harm suffered as a result of a RICO violation, that breaks the causal chain. So even if you were allowed to consider that evidence and that $750 payment, you still would not have RICO standing. Unless the court has other questions, I'll sit down.
Thank you very much, Mr. Taft.
Thank you, Your Honor.
Mr. Wilkins?
Misunderstood my colleague, so I want to be sure that the record is straight. The certificate of eligibility was absolutely required before Brian would even be considered by any basketball team in the NCAA to play ball. Once you get that certificate, the door is open, and he was then offered this athletic tender agreement. And under Kentucky law, in the Henry Conco case, cited on page 7 of our brief, an agreement will imply an obligation to carry out the purpose for which the contract is made. And how do you find the purpose? You look to tradition, you look to the intent of the parties, you look to custom. And indeed, when Brian was ineligible, the athletic department, the assistant, sent this letter out to all the coaches, and he said, Brian is ineligible. He's ineligible to participate in practice, conditioning. He no longer can participate in weight training, sport performance, skill instruction, strategy instruction, and other countable activities. All of these things were given to all of these athletes, past and present, who were certificately eligible and had signed the athletic agreement. And this is the agreement that Brian signed. It's a no-cut 4-year contract. Only 4% of basketball players get a contract like this. Usually it's a 1-year. And he cannot be cut for any athletic reason. This was a right that he had. It was a property interest. And this idea that he got everything he bargained for, that he gave his labors for this scholarship, that was incidental to him going to the University of Louisville. He got a lot more than an academic scholarship. He got the right to have the best coaching and all of these other accountable activities that I've mentioned. Now, when Brian was 16 years old, it's alleged, and it's highly disputed whether or not the facts even come close to a violation of NCAA rules, that his father received money from a runner for some kind of firm that tried to represent athletes after they got to the NBA, as well as a high school coach for expenses and other things. It has never been determined by anyone, any entity, any panel, anything, that this was a violation of any NCAA rule. But yet they say, we can bribe him all the time because he would already accepted bribes when Brian was 16 years old. Now, if you look at the difference, if you read the NCAA rules, there's a huge difference between an amateur status, which Brian was as a high school student, and an enrolled student athlete, which he was when he signed that athletic tender agreement and entered the University of Louisville. The rules are much stricter for those people in that category than those athletes who are high school students. And the expert testimony of John Carnes, he's the compliance officer. He knows the rules. That's what he's been doing for 20 years. He said, no, it is not an automatic render a student ineligible if they had an amateur status, a high school student, and the daddy does something that may look like it's improper. Because things can happen. Eligibility can always be given. It may be a condition, like you got to pay the money back, you got to sit out the first 4 games and stuff like that. But to say that they could, with impunity, bribe his father and suffer no consequences, because when he was 16 years old, his daddy may have taken some money for expenses and so forth, which is highly disputed, whether that would ever render him ineligible. What Adidas did when they paid that bribe, had it paid to his father, they destroyed his eligibility at that moment. He was rendered ineligible right then. And that then, of course, was a direct cause of that was the loss of his athletic tender agreement and his future to play in the NBA. The difference that the district court and what Adidas has seized upon is the constitutional right, the lack of a constitutional right to play basketball. Of course you don't have a constitutional right to play basketball, to be out there on the court. But Brian Bowen had a right to be on the team, to receive all of the benefits that all the players, his 12 other teammates received. He had a right to that, a property right to that, and that bribe took it away. Thank you.
Thank you, Mr. Wilkins. We very much appreciate the argument of counsel and the written submissions and and having you with us today. And I wish we could come from the bench and greet you in the well of the court, as this court has done in its existence until this pandemic. And we're not doing that now. But we're going to have you back sometime, and we'll be able to do that. But we'll shake hands with you from here, and it's good to see all of you, and thanks so much. Case will be submitted. We'll take a brief break, Madam Clerk. versus Casey Hicks. Mr. Willis, you with us? Good to have you, sir.
Nice to be here. Ryan Willis, on behalf of appellant Casey Hicks. With me at the table is Katie McCoy, my colleague.
And you're from Raleigh,
Yes, Your Honor.
and you're appointed in this case?
We're actually retained for this appeal, Your Honor.
Retained?
Yes, sir.
Well, good to have you. Appreciate your work.
Thank you.
Go ahead.
Thank you. Your Honor, we would argue to the court that a conviction for maintaining a drug-involved premises requires that the illicit drug activity be a primary purpose of the premises in the context of a residence. As in the facts of this case, Mr. Hicks resided at the address at 1031 Maple Street in Henderson, North Carolina, and that as other circuits have looked at this issue of purpose, have found that in the context of a residence where someone is sleeping,
Now, this argument, this goes to one count.
it does count four.
Count
Your Honor.
4.
That's correct, Your Honor.
But you were convicted on count 4. Why is it you're going after that count right directly first thing?
Your Honor, when we received the order from the court of oral argument, this was the issue that the court addressed.
We identified that for you.
Yes, Your Honor. And
Okay.
so we,
Well, those other issues are important too.
of course, Your Honor, and I'm happy to address other
Yeah,
issues.
no, but that's good. Yeah.
But other circuits and the Fourth Circuit have said in the context of a residence where someone is sleeping, residing, that the purpose that's required for 21 United States Code 856A1 does not have to be an exclusive purpose. Clearly, that would sort of
So
eviscerate.
what you saying, the instruction was flawed?
Well, I would argue both that the instruction was flawed. However, trial counsel did not object or offer any alternative instruction.
So the instruction was, we're reviewing your claim, that means we're reviewing your claim for plain error?
Well, I would also argue that because trial counsel made a Rule 29 motion on sufficiency of the evidence as to count 4, that there is an argument that there is insufficient evidence that the purpose element of 856A1 was met on the facts of this case. And that both for examining the sufficiency of the evidence in the Rule 29, that the court should adopt a primary purpose standard. This would follow, I would argue to you, the court's decision in U.S. versus Stallworth, and would not be inconsistent with the court's opinion in U.S.
I thought in
versus Wood.
Stallworth, and I realize it's unpublished, right? We're talking to you about this because we don't have anything published on it, but in Stallworth, we rejected the defendant's argument for a primary purpose. He had said sole or primary or exclusive, and we rejected that. We said specific purpose there, and I think trying to get at this idea that it can't be incidental, right?
Yes.
To have something as the purpose, it has to be your intention. It has to be why you're doing it, but it doesn't have to be the only reason. And courts have kind of stumbled around looking for an adjective that feels right to describe what it means to be not incidental, not exclusive. You say primary. I'm a little concerned primary means like the most important, which may also not capture what the statute's saying. Help me, how do we capture what the statute is saying, other than obviously just instructing on the statute?
Well, the statute says the purpose.
Right.
Right? So, I mean, I think, and even the government sort of argued in their response that that actually arguably could be a higher standard. But every court to
You
address
say it
it.
has to be a single purpose?
No, Your Honor.
It
I
can't be
think-
living there?
I would not assert that in every circuit, including the Fourth Circuit that's addressed that. It says,
Right.
because then essentially all you would
Well, there
take
can
to,
be more than one purpose.
correct, it can be more than one
And here,
purpose.
there were what, 4 purposes? Or 2 purposes?
Well, there was more than 2. I think there's evidence that the defendant had a barber shop in his house.
Barbershop and a studio.
A studio, that's right, and that he
and
resided
and
there.
a drug business.
And well, and his mother was
And he
residing
lived there.
too. Correct. So the
Brother lived there.
or had recently moved in. I think she had taken ill and had moved in, and he and
It
his
was a
brother took care of
residence.
her. It was a residence.
It was a valid residence, so, but it's a, maybe there was a business that had 4 divisions, or 3 divisions. Had the drug business, the barber shop, in the music business. Just one business.
So
So it's a purpose, the drug stuff.
I think the court has to require that it be more
You
than
say
just,
there's not enough evidence to prove it was a drug business.
that it was not, well, let me take a step back. What this statute, I would argue to you, Congress was trying to address back in 1986 was the problem of crack houses, of properties being used for the purpose of manufacturing, distributing, and using drugs, and the harm that that caused to a neighborhood. At that time, Congress had already criminalized possession of controlled substances and possession with intent to distribute controlled substances. They're addressing a separate harm in how a property is being used to essentially be a drugstore, to be a storefront for the distribution of drugs and the manufacture of drugs and potentially the use of drugs. A number of individuals congregating.
Doesn't have to do all three of them. Any one of the three would be enough. There's an or in there too.
I agree. But what's not there clearly in the statute is possession. That was not one of the illicit purposes or possession with intent
Well,
to
they found,
distribute.
multiple bags of marijuana,
Yes, sir.
and they found a gun,
Ammunition.
a couple guns, 3 guns,
Yes, sir.
firearm.
Yes, Your Honor.
They found
Well-
cocaine,
Multiple bags of cocaine. Absolutely.
multiple bags of cocaine. They found cash money, $400.
I believe that's correct, Your Honor.
All that's evidence of a drug business.
It's definitely evidence of possession with intent to distribute.
It's evidence of a drug business, distribution of marijuana and cocaine.
It's evidence of a drug business.
And he
Absolutely.
had the BMW out there, it'd all been shot up. That's evidence of a drug business.
But is that evidence to establish that 1031 Maple
You
Street?
found ammunition.
Absolutely.
I mean, we've got lots of cases talk about drugs and guns going together.
And there are statutes that address that. But what the court has to consider is what is required.
So what's required, but the instruction that was given was not objected to.
Concede that, Your Honor.
So you want us to rewrite the instruction and say that it was plain error not to give an instruction that was never offered?
The focus of my argument, Your Honor, is on the sufficiency of the evidence for count 4. And although
Sufficiency of the evidence, I've just recited to you some of the evidence, and that sounds like you lose on the sufficiency of the evidence. That there was lots of evidence that at least a purpose of that residence or location was a drug business. They got all this cocaine and marijuana and guns and all that.
So I think the problem, though, is establishing that the property, that 1031
Cash
Maple
money,
Street.
large amounts of case money go with drug distribution.
And I would concede the jury considered that evidence and convicted the defendant of count 2, the possession with intent to distribute. But what we wouldn't concede is that evidence of what was found during the search warrant on a particular day is sufficient to then say that Casey Hicks maintained that premises for the purpose of manufacturing, distributing, or using illicit drugs. We would contend that there has to be additional evidence of frequency.
What if we add all of the evidence? So there's the evidence of the drugs there, the materials for cooking crack, and the scales, the baggies. There's also evidence of 2 controlled purchases. Just in 1 week, though. It's a short time. And the defendant's own counsel elicited testimony that there was foot traffic, significant foot traffic to and from the house. If we consider all of that, now is that enough to make it, at least temporarily, a purpose of maintaining the house? Was either manufacturing or distributing drugs?
So with regard, I agree with the court, we've got additional evidence because there was evidence elicited, Detective Woodleaf testified about these 2 controlled purchases from the residents over the course of the same week, I believe. I would argue to you that, again, what this statute is trying to criminalize is a property that is causing a danger to the community by the frequency and the type of illicit activity with regard to distribution and manufacturing. And that 2 controlled buys in 1 week with evidence that the defendant's brother had recently moved in is not enough to meet the threshold of that it is, whether it's a significant purpose or a primary purpose, that is what the defendant used the house for. Drug dealers have to sleep somewhere.
But he has to make it somewhere. And so he has the materials to make crack. No crack was found in the house during the search. But he has the materials to make it, and there were 2 controlled purchases at that house. So why is that not enough evidence to say that the house was that's his business location for cooking crack?
I would argue to you that the evidence is insufficient to say that he actually cooked crack at that residence. There's testimony that they found powder cocaine, which is clearly an ingredient for crack, and isotrol,
A cutting agent.
a cutting agent for powder cocaine. There was no testimony in the trial that isotrol is used to cook. There's also no crack found. So I would argue too that the evidence of
Don't we
actual...
have to draw, we have to look at the evidence in the light most favorable of government, draw all the inferences, and we've said in other cases, you can draw inferences from the presence of these materials and the packaging materials, et cetera, about distribution going on there at a minimum, if you have packaging materials. Was there an argument that he was distributing somewhere else?
There's no evidence that he was distributing somewhere else. I think where the problem becomes is...
What if we agree with you? What good does it do this fellow?
It's a fair question, Your Honor.
Sentences, didn't he?
He was convicted of count 1, which was the 922G, possession of ammunition and firearm by a felon. And if you look at his pre-sentence report, it was that offense, although the offenses were grouped, that really drove his sentence.
So the only way out there is the warrant or some version of that, right? And so can I ask you a question about the warrant?
Yes, Your Honor.
What is your best argument that everything else aside, Leon just doesn't foreclose relief here? I mean, that strikes me as the hardest question for you. Like, assume this warrant could have been better, assume they did, yeah. But what's your best argument against the application of Leon?
I mean, candidly, Your Honor, I just don't have a great argument on the warrant. I would concede that is not our best argument. And so I would,
Fair enough. You've got the record you've got.
Yes, sir. Thank you.
But what good does it do if we say count 4 conviction is flawed by bad instruction? Plain error satisfied.
Or that it was, that Judge Boyle got it wrong on the Rule 29 motion on count 4.
Well, our Judge Boyle was wrong, but it's concurrent sentences, right?
That's correct.
So, would we send it back to do anything, or say it's harmless error?
I would argue it would justify a new sentencing hearing in front of Judge Boyle.
Pardon?
I would argue it justifies a new sentencing hearing for Judge Boyle to consider.
New sentencing? Well, you might be a new trial on count 4. You want to retry count 4?
Well, candidly, Your Honor, the evidence with regard to count 1, particularly the ammunition found in the home, separate and apart from the firearms that are found in the house.
Pardon?
There are firearms found in a car, firearm found in the house. The jury, what's interesting about this case is there is a 924C, count 3, possession of a firearm and furtherance of count 2. The jury acquits Mr. Hicks on that, which is a firearm.
We're not looking at what he acquitted on. What's up here are the ones he was convicted on.
Yes, Your Honor.
And sentenced on.
Yes. You're asking me.
I'm not sure we can look at what he was acquitted of and everything. The jury convicted him of 3 charges. Concurrent sentences. If one of those is flawed, what do you want to do? Do we say it's harmless error, or do we send it back and say you can retry it? We'll tell the court, let's try you on count 4. And you might get more than what he got last time.
That's possible. I mean, I agree that there are concurrent sentences. He was convicted of count one. That count drove his guideline sentence. But I would argue to you.
It's an academic question maybe here. It's not something that's not very meaningful.
Well, I would argue to you that vacating count four would justify at least a new sentencing hearing, so that the court could consider.
Get the judge to look at the sentence again,
Correct.
okay? But you're not interested in a new trial.
Well, I've sort of conceded to Judge Hayden's question that the search warrant and the ammunition that was.
Giving up your conviction, your client. I don't think you want to go over here and do that.
No, but I want to be cut to the argument that I think is actually, the most pertinent for the court to consider, and not waste the court's time on arguments that I don't know that there's a good faith basis for me to say we win on them.
I thought your argument for maintaining a dwelling was there's insufficient evidence. You don't want a new trial. You want us to say he can't be convicted of that on
That's
evidence.
correct. That's right.
You want to
On
get
that
rid of
count.
that conviction.
That's correct.
And then under sentencing package, he should get a new sentencing if that's what we were defining.
That's correct. And then, and honestly, we did not brief the issue of the other circuits and the standards of primary or significant.
You plant your feet on no new trial, a new sentencing.
New sentencing, because we are arguing there's insufficient evidence on count four, and we're advocating to the court that you adopt the primary purpose standard when reviewing the
Rushing
statute.
helps you out there. You don't want a new trial. You don't need a new trial if there's not enough evidence that if the judgment of acquittal should be granted.
Correct.
All right, let's see what the government has to say.
Thank you.
Thank you. Mr. Bubar?
Thank you, Your Honor, and good morning, and may it please the court. The Fifth Circuit case, Roberts, is on point for both setting the standard for what should be considered for the maintaining a dwelling count, as well as considering the jury instruction issue as well. In that case, the 1990 Fifth Circuit case, Roberts, which is in the government's papers but wasn't explored deeply, it talked about the fact that the jury should be instructed on the statutory language of for the elements, and that's what it held in that case.
You concede the instruction was wrong?
Pardon me, Your Honor?
You concede the instruction was erroneous?
No, sir, Your Honor. The government and counsel and trial counsel agreed. It ought to be waived, first of all. Counsel agreed, not just didn't object, but pre-trial, in their pre-trial filing, which I believe is Joint Appendix 1.
Would it be fair to say that the failure to object to the instruction has been waived by the government? Because you don't raise it in your brief.
Well, the government didn't object either. Nobody objected. We put them forth
Right, so
together.
you don't.
We think they were proper, Your Honor, yes.
No, but all right.
I think what Judge King might be referring to, the government does not allege that the Rule 29 issue was forfeited, right? I didn't see an argument in your brief that he waived his Rule 29 argument.
That's correct. I was speaking only about the jury instructions, Your Honor. I apologize.
Well, you don't challenge, they don't say they didn't waive or object to the jury instruction. That's what I'm questioning.
The jury instruction was not raised below.
Right.
And was agreed to. And the government would say that it was proper to instruct on the statutory language for the purpose of. There was no modifying language.
If we were to, do we have any right to look at, then on this appeal, to look at the jury instruction and say, this isn't the right one, you ought not be doing this anymore?
From the government's perspective, they waived the jury instruction
The government one is to tell you whether that instruction is good or bad.
Your Honor, I don't believe this is the case to do that.
You need to find another case for that. Is that what you're saying?
Your Honor, we believe that it was proper instruction and that following the statutory language for the purpose of, as Roberts said. Now, Roberts has been cited by this court a number of times in unpublished decisions, in Stallworth and in Worth in recent years. And that court held that it's common English for the purpose of is understandable by the jury, and that it's understood to mean a primary purpose. That's what Roberts originally said. Now, that standard has been changed over time in the Fifth Circuit. In '97, there was the Soto-Silva case, and other circuits have followed, the Sixth Circuit has followed that, a significant purpose or an important purpose. The Ninth and Tenth Circuits have said, No, it needs to be a primary or a principal purpose, to the extent there's even a meaningful difference between the different phrases. Ninth Circuit questions whether there's even a difference. But for the purpose of this case, they were instructed on the highest possible, there was no modifying language. It was the highest possible standard for the purpose of. And they were instructed several times.
So do you just think we can say it can't possibly be plain error to quote the language of the statute verbatim?
I don't believe it can be plain error in this case, Your Honor, because we followed, again, agreed upon by both parties, the elements of the statute are for the purpose of distributing a controlled substance. And that accomplishes the work, according to Roberts, the seminal case, that accomplishes the work of instructing the jury.
On the sufficiency issue, can I ask you, so I'm not sure this is this case, but would you probably concede with me that the language of A1 is kind of a mess and sort of hard to understand? Because, so knowingly, I'm just trying to imagine, can I take a step back? Is using drugs for my own personal use in the place that I live covered by this statute?
Use is covered, Your Honor, I do believe. I haven't focused on this issue for this brief or in this case.
So you're telling me that every single person who recreationally uses drugs in their own house or apartment is violating this statute?
Your Honor, I don't believe so. And
I'm glad to hear that.
Yes.
Why not, though, given the language of this statute?
Because I don't believe that you, in your hypothetical, are maintaining a dwelling or a facility or a outhouse for the purpose of use. If I may, Your Honor, if it's a house for recreational use, where you're inviting your friends over, and you're inviting your neighbors over, and you're inviting people from the town over, and you're inviting the whole world over to come use drugs, there are cases like that. The building was used for the purpose of
If you're doing
use.
that, you're distributing.
Maybe you're not.
Well, if you're giving somebody a drug to use, you're distributing.
We could certainly get to the place, Your Honor, where people bring their own drugs.
This is a place we can all come together in a
We
safe
can all use drugs together in this building.
Okay,
Everybody
so
use their own. Well, but the statute covers that,
It does.
and that makes a crime.
to the,
Yes, Your
okay, so
Honor.
to the extent,
Yes,
You're saying the Department of Justice doesn't prosecute that?
I have not said that, Your Honor.
Oh, I thought you said they didn't think it was a violation.
I was simply following Judge Hayden.
Judge Hayden's.
let's just take a
The
really,
statute covers it.
well, so the really simple example of the
The
person,
purpose is to use drugs, it's covered.
I can see a scenario where the use is absolutely covered. Yes, Your Honor.
so I just want to make sure I understand this correctly. The government does not think that when a citizen is smoking marijuana in his or her apartment, personal use marijuana in his or her own apartment, for this is under this is not covered by this. Not every single person who smokes marijuana in their house or apartment is violating this statute. And to the extent they're not, the government's theory, grounding that in the language of the statute, is that although that is their apartment that they rent or lease or whatever in the language of the statute, and although they are using drugs there, they are not using that place or renting that place for the purpose of using drugs.
There would have to be sufficient evidence, Your Honor, that the residence or the building or the structure is being for the purpose of. And it cannot be, courts have been universal. This court has recognized that in Stallworth, that it cannot be an ancillary purpose or a offshoot. It has to
It has to
be.
be the sole purpose, though.
No, it does not. It does not have to be the sole purpose on one hand, and it cannot be an ancillary purpose on the other hand, Your Honor. It has to be something, and I believe Judge Rushing has pointed out, it has to be something in the middle, and that courts have attempted to elucidate. But Roberts has said, for the purposes of jury instructions, that courts need not specifically say in the jury instruction that it is common language and it is sufficient. The evidence, as we've already somewhat reviewed, is plentiful as for a conviction here, Your
I think
Honors.
this evidence would be sufficient under any of the standards in the circuits. I know you say in your brief the jury was told the purpose, and that's arguably a higher standard if no one told them the means A in this context. But do you think even if we adopted primary purpose or significant purpose or specific purpose that this evidence would be sufficient?
Yes, Your Honor, because it would be a primary or principal purpose. And again, the evidence is that the evidence of both narcotics as well as distribution are plentiful throughout the residence. It's the defendant's residence.
And do you think your evidence is better? I mean, there's some evidence here of so I'm looking at the verbs in the last clause of the statute, and it says manufacturing, distributing, or using. And what's weird about this case is that there's like some evidence of manufacturing and there's some evidence of distribution. Do you, well, first question, do you think your evidence is stronger on the manufacturing or the distributing prong?
I agree with my colleague that there is not a lot of evidence of manufacturing. There is plentiful evidence of distribution, Your Honor. While there is the inositol powder, 3 bottles, of course, and that is the beginning and end of sort of the manufacturing.
Do you know of any cases, this comes up in like the continuing criminal enterprise context. Do you know if there are any cases about whether the jury has to unanimously agree on whether it's a manufacturing case or a distribution case? Because I can imagine a case like this where the government has evidence of both and 6 jurors think the evidence is sufficient of manufacturing but insufficient. You could imagine that. Do you know if there's any case that's confronted the question of whether the jury has to agree on which of those it is?
As to this statute, I'm not aware of that, Your Honor. And certainly the evidence was plentiful about distribution. There were 2 controlled purchases that led up to, and just in the days before the search warrant, obviously that was the place that the defendant wanted to conduct controlled purchases, was his home. It wasn't around the corner. It wasn't at some other building or some other in his car.
Even there, is it a bright line? Say I'm a drug dealer. If I sell drugs, and I 99% of the time I sell drugs on a corner or some other place. But one time, so I'm definitely a drug dealer. I'm in the drug distribution business, but I overwhelmingly sell drugs somewhere that is not my house. If I sell drugs a single time out of my house, does that mean that I maintain my house for the purpose of distributing drugs?
Your Honor, I would point you back to the plentiful case law, again, not in the Fourth Circuit, not before this court, but across the country, for the purpose of it has to be an important, a significant, a primary, a principal purpose.
Okay, so the government agrees that even if I am a drug dealer, the mere fact that I sell out of my house one time doesn't trigger this statute.
It would be hard to see how one time would be using the house for the purpose of distribution of narcotics. I would also add, if I may, that the evidence included multiple digital scales. Those are certainly evidence of the distribution of narcotics. 2 were in the kitchen, 1 was in the recording studio, along with other dime bags of marijuana individually packaged for sale.
Your position is there's plenty of evidence.
A great deal of evidence, yes, sir, Your Honor.
And it's worded to distribution.
Yes, Your Honor, as well.
But those statutes are written in the disjunctive. There's lots of cases on that you charge in the indictment in the conjunctive with the and.
Yes.
But the proof, the proper instruction to the jury is in the disjunctive. All the jury has to define is manufacturing or distributing or using, and he's guilty.
Yes, Your Honor.
But it has to be unanimous verdict.
Yes, Your Honor. And it was in this case both to cocaine and marijuana. There was also the defendant's admissions that the marijuana was his. There were images of the defendant and his residence.
Having drug wars out there and all that BMW all shot up?
It's very concerning, Your Honor, certainly. The BMW was shot up. There were shell casings found in the BMW itself. The BMW was properly searched, and that issue was waived as well, was not raised below, and I'd like to point that out. I would also point out, Your Honor, this came up very briefly toward the end of argument of my colleague, but there was plentiful evidence for the 922G count, setting aside the firearms found in the BMW. There was a firearm found within a foot of the hand of the defendant when the search warrant. Beg your pardon, Your Honor.
To the bed.
Yes, Your Honor.
Was it loaded?
I believe that it was loaded, Your Honor.
You believe, you don't know.
There was a magazine.
What on the record here, was it loaded or not?
There was a magazine.
What was the evidence?
Beg your pardon, Your Honor.
What was the evidence?
I believe the evidence came in that it was loaded and that there was a magazine in it.
Was there what, a 38?
It was a 9mm, Your Honor.
9mm.
Now, that, again, the defendant was under the bed with his hand, perched right between the mattress had to be pulled back. They wanted to see what was sitting there. But that together, the plentiful ammo was all sufficient along with that firearm to convict on 922G. Although the actual search warrant issue for the BMW was waived below, was not raised in the suppression motion. Your Honors, unless there are any other questions for the government, I will conclude my remarks and ask that the court affirm the defendant's convictions.
We appreciate you.
Thank you.
Thank you very much. Mr. Willis, you got anything else to say?
Briefly, Your Honor. Your Honor, I think the question for the court, again, is establishing, did Casey Hicks maintain this premises for the purpose of distribution or manufacturing? And the evidence of what was found on the execution of a search warrant on a particular day, of quantities that could be considered, more than personal use, is evidence that the jury could consider. We also have the evidence of the controlled purchases, but the concerning part for the defendant in that case is that those controlled purchases by that cooperating informant, the government elected not to call that cooperating informant at trial. Detective Woodleaf was allowed over objection to testify that the complainant, the cooperating informant, said Casey Hicks was selling narcotics at 1031 Maple Street. Over objection.
Are you arguing inadmissible hearsay?
That's a confrontation
clause. Well,
And-
hearsay's, and any hearsay is you could argue a confrontation clause.
It was
Trying to make
confrontation clause problem here.
Constitutional issue out of it. But was there an objection to any of that?
There was an objection, and it was allowed in, and the government's argument is it was offered for a non-hearsay purpose. But that testimonial Sixth Amendment violation of Casey Hicks is selling narcotics at that address was offered into evidence with no limiting instruction to the jury.
Did the defense request a limiting instruction?
Did not. And then the evidence of the controlled purchases was just, there was Detective Woodleaf saying there were two controlled purchases.
Hired you too late.
I'm sorry, Your Honor?
Maybe you should have tried the case. I say they hired you too late.
I agree. But unfortunately, I'm here arguing to you, and
But you have to argue you're stuck with the record that
that's
is the
correct.
record.
But what we don't have in those controlled purchases is that Casey Hicks actually sold narcotics to the cooperating informant. We have somebody did, and there was his brother, Vincent Hicks, who had recently moved in, and we would argue
Controlled buys, and they put in evidence they had two controlled buys.
they had two controlled buys, and that's it, from that house. Casey
What they
Hicks,
used for the search warrant.
that's correct. But Casey Hicks had to have the purpose of maintaining the premises for distributing or manufacturing.
Well, he lived there.
He lived there,
Well,
and he had sufficient drugs for the jury.
The jury could reasonably conclude that the person that lived there was running the business
But again, I think what the court's
under
focus
the
is,
circumstances here.
what I would argue to you is there's insufficient evidence that the property itself, that address, was being used on a frequent basis for manufacture or distribution. I would ask the court to consider.
Well, the statute doesn't say a frequent basis. It says permanently or temporarily. Now we have to square, what does it mean to do something for the purpose of distribution temporarily? Surely it means more than just once, as the government conceded.
Right.
But, here, I don't know that you get very far in just saying that it happened a couple times when you have this other evidence of distribution.
What I would say, another point I would ask the court to consider as guidance is the enhancement in the sentencing guidelines in 2D 1.1.
Right.
B12 that deals with maintaining a dwelling for manufacture or distribution. The application note 17 talks about the court should consider frequency and that it be
But
primary purpose.
we can't use the guidelines commentary to interpret the statute, right? Congress told the commission, add something to the guidelines because we have this statute already. And arguably the reason the commission added those sorts of qualifications is because courts were interpreting the statute that way, perhaps. But I think it's backwards to use the guidelines to interpret the statute.
No, I agree. I think it's the court can consider that, right? To your point that other courts, other circuits have adopted that test of primary purpose and frequency. But I would argue to you there has to be more evidence than drugs in the house on one day and 2 controlled buys within the same week to meet what Congress was trying to criminalize here, which was crack houses that are a danger to a community. Because a drug dealer could deal drugs for the most part other places and on occasion at his house. I don't know that that's what Congress was focused on in passing 856A1. It's covered by the possession with intent to distribute that the defendant was convicted of. There has to be more for it to be the premises is being used for the purposes of distribution or manufacture. Thank you.
Thank you very much. We appreciate your work, and we appreciate the work of both of you, and we wish you all the best. If we could do so, we'd come down and re-counsel in the well of the court, but we're not doing that, unfortunately, at the present time. When you come back, we'll do that.
Thank you, Ron.
Hope to have you back soon. Thanks so very much. Madam Clerk, we'll reconfigure the court and proceed to the next case. Final case, Thompson versus Ciox Health, LLC, number 2102. Mr. Bradley.
Thank you, Your Honor.
Good to have you with us, sir.
Thank you. The court issued a order about the jurisdictional, diversity jurisdiction. How do you want to handle that?
It's up to you and counsel. I mean, that's up to you and
Okay,
questions you get.
okay.
I would love to just get this out of the way if we can, just to ask you right out of the gate. The 2 specific questions I have is the complaint alleges, it alleges a headquarters for Ciox, but it does not actually allege where Ciox's principal place of business is.
Right,
Where
Your
does the
Honor.
plaintiff allege that Ciox's principal place of business is?
It's in Georgia.
And then it also does not allege, as I recall, where Ciox is incorporated. Where do the plaintiffs allege Ciox is incorporated?
Also in Georgia.
And you're wishing to make a motion to amend your jurisdictional allegations on appeal?
Yes, Your Honor. Under, that's section 1653 and Rule 10E of the appellate procedure. So we would make that motion. Maybe Ciox will stipulate that their headquarters is in Georgia, the principal place of business.
Those are all the questions I had about jurisdiction.
Thank you, Your Honor. So may it please the court. Here are the questions this court needs to answer. First, does the South Carolina's Physicians Patient Records Act give rise to an implied right of action? Second, if it does give rise to an implied right, can we sue defendants directly under the act, even though the act only mentions physicians and other owners of medical records? And third, if there is no implied right, or there is, but we can't sue the defendants directly under the act, can we still sue them for unjust enrichment? And I'm going to get to each of those questions. So the first question, does the Patient Records Act give rise to an implied right of action? And the 2 critical cases here are Sloan v. Southco and Dema v. Tennant.
Can I ask you, before you get too far down that road, doesn't the Unfair Trade Practices Act have a private right of action?
In South Carolina?
Yes.
I believe it does. It doesn't allow class actions.
And doesn't it also define an unfair trade practice as a healthcare provider charging a fee in excess of 65 cents per page, charging a fee for searching and handling medical records, et cetera, et cetera? It has a definition of unfair trade practices that exactly matches the definition, exactly matches the fees that you're disputing in this case under the PPRA.
Right, and I would say
And it was
that,
enacted in the same legislation. South Carolina legislature in 1995 amended the PPRA, the Con Act, and the Unfair Trade Practices Act to make these amendments about the charges for the fees in all three. And they put the private right of action in the Unfair Trade Practices Act, didn't they?
yes, but you.
Why didn't you mention that in your brief?
Well, we didn't sue under the unfair trade practices.
But you have a right to sue under that. And isn't that informative for whether we should imply a right to sue under the PPRA directly? Isn't that one of the prongs of the analysis?
No, I think
Enforcement?
that's right.
Yes.
But you got to look at each statute on its own terms, because the Patients' Records Act has a whole bunch of other provisions that should be enforceable as well, that you wouldn't be able to get to under the trade.
What are those provisions that you're suing under in the PPRA that you can't sue under, you can't sue for in the Unfair Trade Practices Act?
There are, do you have a copy of that?
And if that's the case, doesn't that suggest the legislature doesn't want you to have a private right of action to sue for those?
You know, it's has to do with, you know, whether they can withhold records. For instance, this is an example for unpaid medical bills. But no, I think you have to look at the PRA. Just because you can sue under another doesn't mean you can't sue under this one. And I see what Your Honor is saying, that can inform it. But I think you got to look at what the South Carolina Supreme Court has done with, say, the Con Act versus the Patients' Records Act. So, you know, what I would say is
the exact remedy that the legislature, when they added these requirements to the Con Act and the PPRA, they also added a private right of action, and they did it in the Unfair Trade Practices Act. Why is that not, why doesn't that answer the question of how you enforce the provisions you're trying to enforce in this lawsuit?
Well, even if you can enforce it, that doesn't mean we can't enforce it under the Act directly.
Sure it does. South Carolina doesn't imply a right of action in a statute when you already have a right of action. That's certainly the case when it comes to equitable remedies. They don't imply an equitable remedy when you have a right at law. And the fact that they created a right at law in a different statute and didn't do it in this one for the exact same things is highly probative of whether they wanted to create an implied right of action or this statute, isn't it?
Well, Your Honor, we didn't sue under the Act. I did not prepare for that. I would have to go back and look at that Act. There are other prohibitions on that, you know, on bringing that claim.
You can't bring a class action.
Can't bring a class action.
Yeah.
And you want to bring a class action?
Yes, Your Honor.
Right.
And I think that's important. And we'll actually get to that when we start looking at unjust enrichment and also whether we can disregard the plain language. So I do think that's important. You can't bring a class action.
Again, I just want to flag, you did not put this in your brief, and I think it's important, and you agree it's important, and neither party raised it.
Right, but I would argue that because you can't do a class action, you know, that's why we would sue under the Patient Records Act. And
I understand why you'd want to, but
right.
I guess the question of whether you're allowed to is a bit different.
Yeah, okay. Well, so, you know, what I would say is Sloan says that if a statute is enacted for the benefit of a private party rather than the public, you can bring an implied right. And the thing that the court found determinative in Sloan was that the statute at issue didn't have its own enforcement mechanism.
Don't you have a massive threshold problem before we get, let's talk about the statute you've sued under. It strikes to me, before you get to private right of action, you have a massive threshold problem, which is that there's a list of people that are regulated by this statute and they're not covered by it. So
you're talking about, I'm sorry,
let's assume for the sake of argument you have a private right of action. You could have sued the providers because they are, assuming there's a private right of action, providers are covered by this statute, But you didn't sue the providers, you sued someone who is not covered by the language.
Okay, and, right, and so we're skipping ahead to the plain language question, because we're, as you said, assuming there's a private right. Well, why don't you sue the doctors? And that's the question that the Sixth Circuit.
I suspect I know the answer to that too, because if you sued the providers, it would be hard to get class certification because you'd have to sue a whole bunch of different providers in one proceeding. Is that the reason?
That is an important reason, you know, as a practical matter, but, you know, the other reason is, you know, look at what the plain language test is. It's a line drawing test, right? So, you know, we can all read the same questions and have a different opinion. I mean, I'm sorry, we can all read the same cases and have a different opinion about whether those cases cross the line of when you can disregard the plain language. I think the question that you're getting at, it boils down to the question the Sixth Circuit asked in Faber and the Seventh Circuit asked in Record Quest, which is, you know, why don't you sue the doctors? And the answer is because it's just not economically feasible. There's no way you can justify bringing an action against an individual medical practice based on the cost of bringing that case compared to the expected recovery. So if you can only sue the doctors, it renders the Patient Records Act meaningless. So that's the answer to the question. Why can't you sue the doctors? You're gonna, I'm sorry, Your Honor?
Patients generally don't like to sue their doctors.
No, they don't normally
Most
like to sue their doctors. And, you know, my point would be that whether you went under, because it prohibits class actions, whether you went under the Unfair Trade Practices Act, or if you tried to sue the doctors individually, you're gonna be missing out. You know, there's going to be a huge.
Why on earth does that matter
Yeah.
for how we interpret the statute? Maybe the South Carolina legislature knew all this and they said, but we only want you to be able to sue this list that we specifically put in the statute.
Right. I think, though, and I, you know, I understand your argument, but I don't think that's true. I mean, I don't think the South Carolina legislature, when they enacted the Patient Records Act in 1997, envisioned this industry of large companies that go out and try to squeeze every ounce of profit they can out of
You're saying
providing
there's a
medical
statutory
records.
loophole. You're saying over time, a loophole has been created where physicians realize this is how the statute's written, and if you use this other mechanism, you know, a loophole exists. Where is the canon of interpretation that says courts can fill statutory loopholes by rewriting very plain, unambiguous statutes?
Well, you've got, in South Carolina, the South Carolina Supreme Court has said it will look at modern economic considerations, and I believe that's the Keene case, which we cite in our case. But look.
Why'd y'all wait till you got up here to suggest that this issue ought to be certified to the Supreme Court of South Carolina?
Well, Your Honor, you know.
I'll tell you, you know, I don't know. It's the reason I asked the question.
Yeah. So, Your Honor, the question of certification, I think, comes down to a matter of comity and federalism. It's really up to Your Honors, right? And I know there's the cases.
But you didn't ask
we didn't.
Judge Hendricks to certify the question.
We did not, Your Honor.
Court.
We did not, Your Honor.
And this wasn't a case where you sued them in state court and they removed it. This is a case where you sued them in federal court, right?
Right. So my answer on the certification issue is it's, like I said, that's really a matter for your court to decide. If you think there's an unsettled
No,
principle.
I think Judge Heitens is pointing out it was a matter for you to decide, and you decided you wanted a federal court to decide this question, not a state court.
Okay.
Is that right?
Initially, you did.
Initially, we did because we knew we would get, well, no, because we knew we would get removed under CAFA.
But when you lost, you threw in an alternative position,
Okay.
certified.
Okay.
I'm not, I assume that's what you.
That's what happened, Your Honor. You're right. And there's the cases saying it's disfavored in those circumstances. I'm not sure that makes sense.
Under those circumstances. And our answer could be, well, even if, looking at all those circumstances, we should try to get the law right.
I agree, Your Honor.
The final bottom line for all of it is we ought to have the right answer.
Right. And that's what I was saying. It's a matter of comity and federalism.
They're best able to decide what South Carolina law is.
That's right, Your Honor.
Fourth Circuit Court of Appeals. I mean, they being the Supreme Court of South Carolina. Even if we decided it, it wouldn't be precedent, it wouldn't be controlling. It's just there.
Right. So I want to get back now to where we were, which was this remedial gap. And we would argue that because you can't, as a practical matter, sue the doctors. You can't sue a class action. You can't bring a class action under the Unfair Trade Practices Act. Well, where does that leave me? Well, if you don't agree with me that we can disregard the plain language, there's still the unjust enrichment claim. And it's important because what the district court did is, first of all, it skipped to the question of the plain language, and then it went back and said, well, you don't have a private right either. It didn't really give much analysis there. And then it dismissed the unjust enrichment claim without any analysis. So I'd actually like to first go back because we didn't finish on the private right. So what I said was Sloan stands for the proposition that if it's enacted for the benefit of a private actor, you can have a private right, an implied private right. So the defendants hang their hat on DEMA, and they say that that case holds that a statute that benefits medical patients can never give rise to an implied right. And then they also say that DEMA stands for the proposition that the more likely a member of the general public can become a member of the group a statute benefits, the less you can read an implied right into the statute. But how does that make sense? Right? That would mean that the more widespread the conduct is that violates a statute, and the more people who are harmed by that conduct, the less you can read an implied right into a statute. DEMA doesn't say that. No case says that. It's a made-up proposition with no basis in law. So what did DEMA actually do? Well, the court pointed to exactly two reasons for denying an implied right in the Con Act, and the first was, quote, the expressly stated purpose of the act was to, quote, serve public needs, and second, the act has its own, quote, enforcement mechanism, including criminal penalties and fines. That's it. That's all it says. It doesn't say that a statute enacted for the benefit of medical patients can never give rise to an implied right. It doesn't even suggest that. No, the reason the court found no implied right in DEMA is because the Con Act was enacted for public needs and it had its own enforcement mechanism. And that is important. And the last point about no enforcement mechanism is important because every single case they cite for their made-up proposition about the size of the group of statute benefits involved a statute that contained its own explicit enforcement mechanism, like the Con Act, but unlike the Patient Records Act. Every single case is distinguishable on that basis.
And just to be clear, you do have an enforcement mechanism here, right?
Right, but it's an inadequate one.
Because?
There's going to be a remedial gap. If you sue the doctors, you know, again.
No. You have a remedial mechanism here to sue healthcare facilities or healthcare providers under the Unfair Trade Practices Act for everything that you're complaining about.
Yeah. So one thing I would say under the Unfair Trade Practices Act is that there's the right to access your medical records. It's not just about overcharging, right? So that would be the point.
And that's
Again,
the
there's
one,
a
that's the one where
remedial gap.
the PPRA actually does have its own enforcement for that one piece of accessing medical records. The PPRA itself actually makes an unreasonable refusal to release a medical record subject to disciplinary action under the state medical board, right? So that's the only piece of the PPRA that actually has its own enforcement in the PPRA itself. You don't even have to go to the Unfair Trade Practices Act for that one, right? That's enforced by the medical board.
That one piece is. Okay, well, I think when we're looking at whether there's a private right, I think Sloan is the more instructive case. So Sloan also involved overlapping statutes. It was the South Carolina Payment Protection Act and South Carolina's Little Miller Acts, which were modeled on the federal Miller Act. And the court below denied an implied right under the Payment Protection Act based on cases holding there is no implied right under the Miller Act. The Supreme Court specifically rejected that approach and found an implied right under the Payment Protection Act because it, quote, essentially picked up where the Little Miller Acts left off by outlining a more extensive payment protection scheme dedicated specifically to subcontractors and suppliers. You have to look at each statute on its own terms. The Patient Records Act explicitly gives enforcement mechanism. The Patient Records Act explicitly gives patients the affirmative right to access their medical records, and then it has all those provisions that expand on that right, including the fee caps. The Con Act has nothing to do with patients. It doesn't give patients any affirmative rights, and while it does set forth what healthcare facilities can charge, it has nothing to do with medical records otherwise. So I would say that the Patient Records Act is just like the Payment Protection Act in Sloan. Even though it overlaps on that one provision with the Con Act, it sets forth an extensive scheme to benefit plaintiffs, but contains no enforcement mechanism, so that an implied right is necessary for patients to vindicate their rights. That's the language they used in Sloan. Their other argument is that there's no implied right because DHEC and the Board of Medical Examiners
Why
have...
don't we ask them what their arguments are?
I'm sorry, Your Honor?
Why don't you know what that red light means?
I'm sorry, Your Honor. Okay.
Yeah, well, I say, why don't we'll let them explain what their position is.
Okay, and I really do want to get to unjust enrichment,
Pardon?
but I'll do that on my...
You have some rebuttal, but you were explaining their position. I want to get them explain their position.
Oh, I'm sorry, Your Honor. I thought you were telling me...
Your time's up. I'm going to wait till you, I don't need to hear their position from you. I want to hear it from...
Okay. Are you saying my time is up?
Well, it's red light.
Yes, okay.
That's what that's for.
Thank you, Your Honor.
Yes. Mr. Bentheim?
May it please the court, Gilad Bentheim on behalf of Appellees Saks Health LLC and Scanstat Technologies LLC. If it's okay, Your Honor, I'd like to pick up on some of the questions that you identified from my opposing counsel, and I think
Speak a little louder.
Oh, I'm sorry. I wanted to just pick up on some of the questions that you raised with my opposing counsel, because I think they resolve the issue. If it's all right, Judge Heitens, I'd like to start with your question first, which is, why not sue the provider? And the answer that my opposing counsel gave is that we wouldn't have class action available. But the important point to recognize is the legislature, the General Assembly, placed those limitations into the statute. They're unambiguous, and no one claims otherwise. And the problem that my opposing counsel identified would be exactly the same in a world where SIACs and Scanstat didn't exist. In a world where there was no record providers and hospitals were doing this by themselves, you still wouldn't have a plausible class action along the lines they're identifying, because it would be the hospitals you'd have to go after. You cannot change and rewrite the General Assembly's plain language to give yourself a right of a class action, especially where it wouldn't change, even in the ideal world that they're identifying where my client doesn't exist.
So can I just confirm this? So under South Carolina law, SIACs is not allowed to own these records. Is that right?
That's correct, Your Honor.
So to the extent you're owning them, you're doing it as sort of a bailee or an agent of providers, right?
We're not owning them at all. We are the ROI service, the retrieval of information service, would retrieve the information either from the hospitals themselves or the hospitals.
No, but I just mean to the extent that SIACs has possession of them, the only way that is not itself illegal is if you're doing it as the agent or bailee of the lawful owner.
Yes, Your Honor.
Okay. And so then when you charge, and then you agree that under South Carolina law, they have a right to get the records from their providers. The South Carolina law says if your provider is holding your record, you have a right to get your record from your provider.
Under the PPRA, it's from a physician or a medical record owner. Under the Con Act, it's from the healthcare provider.
And so that when they make a request to their provider and their provider refers it to you, the provider is doing that as part of the provider's obligation to supply the records, right?
Yes.
Okay. So that when you then supply them and charge them a fee, you are doing that as an agent of the provider.
Sure, yes.
So that would mean that for purposes of suing the provider, they could, I understand your point in the brief that says you normally can't sue an agent for the acts it takes as an agent, but you can definitely sue the principal for the acts that the agent does on behalf of the principal.
There is no claim in this case that the appellants could not have sued the hospitals under the act to the extent that SIACs or Scanstat violated the act.
To the extent that you're charging more money than the statute allows the provider to charge,
and that is a private right of action.
Right, and that is imputed right back to the, would be, yes, fair enough on the, okay. So you're not disputing any of that. It's just you're saying you can't sue the agent for its acts as an agent. You have to sue the principal for the acts of an agent.
Under the very plain text of the PPRA, that's correct, Your Honor.
What about their unjust enrichment claim? They say, sure, even if you were the agent, you didn't remit the fees to the principal, and unjust enrichment lets us sue the person who's holding the fees because they have the money.
So, Your Honor, that's a sort of general principle of unjust enrichment, but I think as the Sixth Circuit made very clear in Faber, who you can sue ultimately depends on who the statute allows you to sue. And I think the question you're asking gets back to the precursor question, which is, well, is an unjust enrichment action even viable here, where the plaintiffs are the master of their complaint? The sole basis for the unjust aspect of unjust enrichment is the violation of the statute.
But that's what I just wanted to clarify is, even if we go through analyzing who could they sue under the statute, there's still this kind of unanswered piece about unjust enrichment, and the answer to that is whether there's a private right of action. Right? There's not another answer to unjust enrichment that I saw in the briefs, at least. That kind of, your argument in response to that goes back to there's no private right of action, and if you have a remedy at law, then you don't imply a remedy in equity.
So I think that, Your Honor, there are maybe 2 points. If you do have a remedy at law, if this court were to read an implied private right of action into the PPRA, then yes, you would not have a remedy for unjust enrichment. That's just basic election of remedies. But I think the other argument is, in a world where there is no implied right of action, then this court has determined that the legislature did not intend for there to be one. And then under Hambrick, under the third restatement, you do not use an unjust enrichment to circumvent that plain language. And so you wouldn't have an unjust enrichment action in either situation, either because of an election of remedies or because it's improper.
Tell me about the implied right of action and why we're not talking about the explicit right of action that the South Carolina legislature created.
So, Your Honor, as you noted, and I think as you asked the other side, nobody briefed that issue, and I'm not personally familiar with the Unfair Practices Act, but I would say that from what the other side noted, it is of a piece with what you've seen in their pleadings. They didn't pursue the Unfair Practices Act because it didn't let them have class action. They didn't pursue it under the Con Act, which, as we briefed, was really the proper statute in a world where there was a private right of action. That the providers here are not physicians, they're hospitals. And so they don't fall under the Physicians Patient Record Act in any world. They didn't go under the Con Act because the South Carolina Supreme Court already has been explicit that that does not have a private right of action. And so they go through the PPRA, but as we've briefed, it also doesn't include a right of action. And now, as I'm hearing, the single aspect of it that they're most concerned about is the element that the board explicitly can enforce, the withholding of records improperly. So it is of a piece, Your Honor, with the point that there is no reason here to believe that the South Carolina Supreme Court, and of course this court's sitting in diversity, and so that's the law we're going to look South Carolina law as interpreted by the South Carolina Supreme Court. There's no reason to believe the South Carolina Supreme Court would disregard the plain text of the PPRA, disregard its ruling in DEMA, and rule that there's an implied right of action here. And I'd like to address Sloan for a minute, because Sloan is the exception that proves the rule. South Carolina applies actually, in my understanding, a unique single-factor test for determining whether or not to imply a private right of action. That's whether the statute is enacted for the special benefit of a private party. It's unique, and it's an incredibly high bar. By my count, since 1985, when the South Carolina Supreme Court introduced the statute, this rule in Whitworth, it's addressed the question 12 times. In 11 of the 12, it has said no private right of action. Sloan is the one time it did, and Sloan's never been cited again for the purpose. It's never been distinguished because the court doesn't think that it really is a relevant thing to deal with. It is an outlier, has never been addressed again. It is so unlike all the other situations that the court has dealt with. And if you look at some of the classes that the South Carolina Supreme Court has identified and said, this doesn't count as a private party, drunk bar patrons who get served an extra drink in violation of a statute, not a private party. Inmates who voluntarily opt into certain work programs, who aren't paid the prevailing wages they're allowed, not a private party. Here we're talking about every single medical patient in the state of South Carolina. It's just not plausible to believe that the South Carolina Supreme Court would dispense with its years of its very high bar treating the implied private right of action as a very high bar, dispensed with its ruling in Dema, which was, again, on the same fee limit and with the same access right to records, and said, you know what, that's for the benefit of all healthcare of all people receiving healthcare. That doesn't count. There's no reason to believe that they would go any differently in the PPRA.
Did Sloan even go as far to say there was an implied private right of action? I thought it said this makes you a third-party beneficiary of these contracts, right? Looking at the statute and the purpose of the statute, we can imply that you are a third-party beneficiary of contracts outside the statute. I guess it's murky on what they did there, but
Your Honor, Sloan has a very convoluted appellate history afterwards with the Shirley
right.
case.
Shirley said there's not a tort. There's not an action for tort.
So what Sloan said, and my opposing counsel got into it a little bit, was that there was this very unusual world where the federal law governed this space, and South Carolina law governed the space, the Miller Act and the Little Miller Act, and there was still a remedial gap for particular people, contractors and subcontractors on government programs. And so by adding yet a third act that specifically gave them those rights, it was fair to read in that there was something as for that very specific group that was missing and that was needed to be provided. There's no, it's just not analogous here. There's no analogy here to all medical patients in the state of South Carolina who have the right to records, to access records and to a certain fee cap under the PPRA. I would like to touch for a moment, Your Honor, Judge King, on your point about certification, and I think Judge
I'm going
Heitens.
to ask you about that at some point. Yeah, you go right ahead. What do you think of that suggestion?
Yeah, so in addition to what I've just mentioned, which is that there's really no question under South Carolina law how the South Carolina Supreme Court would deal either with the implied right of action or the plain language of the statute only applying to physicians and owners of medical records. But as this court has mentioned, the appellants filed this case in federal court, not in state court. And you see in their reply brief, they say that they mentioned repeatedly how novel this question was. And yet this novel question was not brought in state court. They didn't ask the district court to certify it. And only once they got here did they ask in the final sentences of their conclusion with no argument in the alternative that this should be certified. This is gamesmanship at its clearest. And even if this weren't as clear as it is, and it's respectfully very clear what the South Carolina Supreme Court would do in the situation, it would be improper to certify this question at this late stage.
Well, we're supposed to decide the case under the proper law, and we can't bind the South Carolina courts by making a decision on South Carolina law. We don't. There's only the Supreme Court of South Carolina can do that.
Your Honor, that's absolutely right.
You're right. I'm not saying that, and they waited and didn't do anything. I don't think a principle of waiver comes into play. They can't come up here and get us to do it just because they brought the suit over here. It's still up to South Carolina. We got to find, if we agree that it's clear with you, that we got some cases that help you on that.
So I'll take your last. I agree, and we're not arguing.
One of our greatest judges, Judge Hainsworth, back in 1984, wrote an opinion about this certification stuff, and he said pretty much what you said.
And Your Honor, we're not arguing waiver.
They bring a case here and all that. We ought to just decide it and take our best shot.
That's exactly right. So we're not arguing waiver.
But we've had other cases that say the other thing. We're required to do it right.
The point I think we're making is there's 2 points. One is that the right answer here is incredibly clear. The South Carolina Supreme Court said it in what we think is a dispositive ruling in Dema. Their entire corpus of the South Carolina Supreme Court's rulings on the implied private right of action make clear that this is not something that they will presume lightly, especially as Judge Rushing mentioned, where there is going to be an additional enforcement mechanism in the Unfair Practices Act. I'd say the standard in South Carolina, what makes it unique, is really a one-factor test. This, for the purpose of private party, and the additional enforcement action is supportive. So it certainly would support the idea that there is no implied private right of action here. But the point we were making about the appropriateness of certification is that aside from the fact that this court can easily determine the question on their own, there is something problematic about the way it was brought up. And to the extent that this court feels that it's unsure, it wouldn't bind the South Carolina courts to say, this is how we decided on this record. We don't think it's appropriate to certify. So I don't think the fact that this doesn't bind the South Carolina Supreme Court means that this court should or should not certify the question, especially given here that it's I think, very straightforward. I think I've addressed all of the questions or all of the issues that I think we need to address. If the panel has any other questions, I'm happy to answer them.
Thank you very much, sir. We appreciate having you here. Yes, Mr. Bradley, you.
Thank you, Your Honor. So first thing, the South Carolina Supreme Court did explicitly hold there was an implied private right of action in the Payment Protection Act in Sloan. That's at 659 SE 2nd at 163. And I think Sloan definitely shows that you got to look at each statute on its own. And it's the question, does it benefit a private party? Yes, it does. There's a private right of action under the Patient Records Act. And so that brings up to this question of unjust enrichment, the payover defense. If the agent still has the money, you can get the money from the agent. You don't have to sue the principal. That's a venerable proposition of law. It's restatement comment B, restatement section 65 comment B. There's 2A CJS agency section 375 says the same thing. We cite cases that say the same thing. And South Carolina recognizes the principle too. It's not in our briefs, but Nobles versus Mosley, the Supreme Court, it was in the context of an escrow agency, said that the principal is not a necessary party to a claim for unjust enrichment. And the cite for that is 70 SE 2nd 247 at page 248. I want to clear something up on that point because we cited the Harwood case. That's where the Eastern District of Wisconsin referred to this rule as an issue of agency law and said it was, quote, a different theory of liability from unjust enrichment. And the Seventh Circuit said the same thing. It's not a different theory. It's just that old venerable proposition that your status as an agent cannot defeat an unjust enrichment claim where those elements are met. You know, again, comment B to section 65, the CJS, look at the Sheboygan case that Harwood quotes, and look at Nobles versus Mosley. So under South Carolina principles of law and equity, we can sue defendants for unjust enrichment as agents of the doctors and other owners of medical records because defendants still have the unjust gains. And allowing us to do that makes sense. Why should we have to sue the doctors when doing so, even if it were economically feasible to bring individual practice actions against the doctors, why should we have to? It's the defendants are the ones who charge the illegal fees. They're the ones who profited from the fees at plaintiff's expense. So it doesn't make sense that we should have to sue the doctors who would then turn around and have to sue the defendants anyways. The law doesn't require us to run around in circles. And even if there's not an implied right under the Patient Records Act, Section 44 of the restatement doesn't say you can never have a claim for unjust enrichment if there's no private right of action under a statute. It allows it where it would conflict with the other remedies and liabilities in the statute. And we don't have that. And South Carolina has taken a flexible approach to unjust enrichment. I would point you to Columbia Wholesale Company versus Scudder. The site for that is 440 SE 2nd 129. There, the Supreme Court considered whether a supplier who had failed to pursue a mechanics lien could nonetheless pursue a claim for unjust enrichment. There's a split of authority on that around the country. The court recognized that split, but held failure to pursue a mechanics lien will not bar an action for quantum merit recovery if a plaintiff can otherwise prove circumstances establishing unjust enrichment. And even in DEMA, the court recognized the potential unjust enrichment claim. Now, it didn't reach the issue because it waited. It looked at whether, Hambrick might bar it, and it looked at Iconco, that's an Eighth Circuit case that stands for the proposition that even if a statute doesn't have an implied right, you can still have a cause of action. And the court ultimately didn't reach the issue. So you look at Hambrick, which is what they cite. Well, Hambrick involved the unauthorized practice of law. And in South Carolina, the Supreme Court has exclusive jurisdiction. And as they mentioned in Hambrick, the only remedy for the unauthorized practice of law in South Carolina is to bring a declaratory action in the Supreme Court's original jurisdiction. So Hambrick is really...
Red light again.
Thank you, Your Honor. I'll sit down.
Thank you very much. We appreciate it. I think we understand your position. We appreciate the arguments of counsel, the briefing, good briefing. We'll take the matter under advisement. And Madam Clerk, we